where we would have interrupted his cross-examination at 11:45 with that discussion. Advocate Mpofu, I want you to resume and wrap up and up until 2:30. Thank you.
Thank you so much, Chairperson. Hopefully I can even finish before that. Can we, good afternoon, Mr. Kakana.
Good afternoon.
Yes, there's an email that you would have been shown during the lunch break. If Advocate Bauer has got it, she'll put it up.
You have it? Okay, it's being processed to be put up.
Thank you. That's an email from you. You remember you said no, the quality check was only done in respect of the draft, but not the final report.
Yes, I remember that.
Yeah. Now that email is from you to address to Busisiwe Mkovane, Public Protector, 17th June 2017 at 1:52:05 p.m. That is 2 days before the release of the report, correct?
That's right.
And there you say the subject is final draft, all right?
Yes.
And then you say, hi, PP, find attached, excuse me, find attached all inputs discussed. Unfortunately, Matlawe is not here. I think you wanted to say here. I went over it and have cleaned it all up. Regards. You remember that email?
Yes, I think I remember it.
You think you remember it? Okay.
I remember it, Council.
Thank you. The emails then obviously suggest, firstly, it relates to the earlier instruction by the PP for you to run this by Matlawe. You remember that, the one before lunch?
The one before lunch, weren't you referring to an email in May?
Yes. I was referring to an earlier email. I can't remember the date now, but whatever, let's say it was in May, June, whatever it is. But it's the same, the point I'm making is the same Matlawe that she had instructed you to do the quality assurance at the draft stage, correct?
Yes, it's the same Matlawe.
Yes, and therefore you are explaining here that for this particular instance, Matlawe is not here, but you had done the quality check, correct?
Yes, I had done the quality check.
Therefore, it was false evidence to say that no quality check was done before the final draft, correct?
No, that's not correct.
So the final quality check that you did was not before the final draft. Which part is not correct?
After I make my own quality assurance, Matlawe had to do the quality assurance as well.
Yes, but you said, unfortunately, he was not here. How can that be? Was that the fault of the public protector?
No, I don't know whose fault was that, but I do state that Matlawe is not here.
Yes, but Mr. Kekana, please, man. The impression you were creating was that the public protector did not want the report to be quality assured. That's what is being reported in the media. I'm trying to demonstrate to you that, firstly, it was quality assured by you. It was probably quality assured by Matlawe after she instructed you to do so in May. And that at this stage, to the extent that it might not have been quality assured by Matlawe, it was because he was unfortunately not here, according to you. Is that a fair summary of the position?
Chair, my position is that the final report was not quality assured by Mr. Matlawe.
But it was quality assured by you.
I indicated that.
All right. Now I think that's fine, Mr. I think the members will just make out of that what they should. Now let's go to TK4 quickly.
Yes, I'm there.
Right. This is the document that you said was handed over by the economist from SSA, correct?
That's right.
Right. Now, it says it is recommended that the following sections in the Constitution relating to the South African Reserve Bank be amended as follows, and that all corresponding legislation be duly amended. Okay, you and I established before lunch that there's nothing wrong with recommending a constitutional amendment. South Africans do it all the time, and even our favorite commission, the Commission on State Capture, made recommendations like that. You remember that evidence?
I remember we spoke about that, Council.
Yes. Okay. Then it then says 224.1, that is now the clause of the Constitution. And the recommended changes are following. The primary object of the South African Reserve Bank is to promote balanced and sustainable economic growth in the Republic while ensuring that the socio-economic well-being of the citizens are protected. You see that part?
Yes.
Now, how can that be harmful to anybody, ensuring that socio-economic well-being of citizens are protected? Do you find it harmful?
Chair, as I indicated before, I didn't understand what was the purpose for us in going for an amendment of the Constitution, as I did not find it relevant to the investigation.
Okay, that's fine. That's congratulations. But do you, apart from all that, think that the socio-economic well-being of the citizens is something that is to be commended or promoted? The protection of the socio-economic well-being of citizens.
Yes, in general, I believe that we should protect the socio-economic well-being of citizens.
Thank you, Mr. Kakan. And the next one is the South African Reserve Bank, in pursuit of its primary object, which is now the socio-economic well-being of citizens, must perform its functions independently and without fear and favor or prejudice, while ensuring that there must be regular consultation between the bank and Parliament. Remember, the original document said the cabinet, and then it was changed later to Parliament by the public protector to achieve meaningful socio-economic transformation. Is there something wrong with that? In general, in the same vein as the previous question?
Well, in general, yes, I wouldn't believe there wouldn't be anything wrong with protecting and transforming socio-economic of the country.
Yes, thank you. And right, and is it fair that someone whose only sin is therefore to promote the socio-economic well-being of citizens be projected by the real owners of South Africa as an incompetent and a mad woman?
I don't know, what are you referring to there, Chair? Maybe can I be assisted on that?
No, I'm saying, you live in South Africa, do you regard it as fair that someone whose only sin is to suggest that there must be all these things you and I spoke about, socio-economic well-being of citizens are protected, should be projected by apartheid apologists and clever blacks as a mad woman and an incompetent mad woman?
Chair, I've indicated my general view that indeed it wouldn't be a bad thing to promote or protect the socio-economic well-being of our citizens.
No, thank you. No, fair enough, Mr. Kakan. You did answer. I'm sorry, Honorable Chair.
Yeah, I just wanted him to conclude his response.
Okay.
Are you done, Mr. Kakan?
Yes, I was done, Chair. I was just saying that my view was that in general, it's not a bad thing to promote or transform socio-economic well-being of the citizens of the country.
Thank you.
Okay.
Right. Excuse me. Now, before we get to the last topic, I'm just going to ask you something about the Gupta leaks. Firstly, let me preface it by saying that the public protector will deny that she said you must not rely on the Gupta leaks. The only thing she did was to caution about the authenticity of some of that information. Because at that stage, remember, you have to think back, this is 2017. At that stage, there were some questions that were being raised, but she never gave you a blanket ban not to use that information. Would you agree with that?
Chair, as I indicated, I was only informed by Mr. Ndo that the PP did not want us to follow the Gupta leaks. Okay,
that's fine. Now, let me ask you, yeah, Mr. Ndo will then come and talk about that, hopefully. Excuse me. So sorry, Mr. Kakan, I won't burden you with what you got from somebody else. But I'm now asking you a general question along the lines that I asked you before. Whether it is fair to do this to a human being. When she says that we need to be sure about the authenticity of the Gupta leaks, then she's condemned. When she says the IGI report has now been authenticated, I can use it, then she's condemned. What must the public protector do in order to attract the favors of the owners of South Africa?
Chair, I really don't understand that question.
I'm sure you don't.
You know.
It's fine. But no, it was about fairness, but I don't think, yeah, it's something you want to comment on. But the other issue is has then to do with your own personal situation. We've already dealt with your disciplinary hearing. There was an independent chairperson, correct?
Yes, I believe there was an independent chairperson.
Thank you. But I'm just doing this apropos. I don't want to get into those issues as to why you were suspended and so on. But just again to highlight an issue that I raised with you yesterday about the difference between investigation and adjudication. By the way, were you aware that Mr. Namasisi held a view regarding this matter of the differentiation between adjudication and investigation? Did you come across his opinion on that issue?
I don't recollect. Are you now referring to the Freder report?
No. I think, in fact, I'm not sure whether it was a general opinion or whether it was in respect of a particular report. But we will deal with that with Mr. Namasisi if he's called. I just wanted to know whether you are aware that he held those views.
I don't recall. I know Mr. Namasisi made a lot of inputs on numerous reports. I don't recall that particular one.
Yes, no, I agree with you. And Mr. Namasisi also wrote about something that I think is going to be relevant for this committee, namely the right to a hearing. Remember, one of the big things about this process we're under are the instances where it is said that the public protector did not give so-and-so a right to a hearing before remedial action. Are you aware that Mr. Namasisi, one of his well-written opinions, I must say, was to the effect that there is no need for a person to be given Audi twice. And by that I mean, if you get your hearing before the preliminary report and the findings are made against you, then it comes back to the public protector. For the remedial action, there would have been no need to give you a second Audi, and that practice is what was followed. Are you aware of this? If you are, you are. If you're not, you're not.
I remember there was some debate around that, but I don't remember how it was concluded. But I do remember that there were those that were saying that there was no need for a second Audi, and there were those that said that there was a need for a second Audi.
Yes, no, thank you. No, that is fair. And in fact, that question was only settled in the CR17 case more recently. But during your time, you are quite right, there were different views about it, correct?
Yes, there were different views, if I remember well.
Yes. The other one, and you're saying you're not aware of which of those that Mr. Namasisi correctly, or I'm sorry, strongly supported.
You mean the view about Audis?
Yes, no. I'm saying I was putting to you as a proposition that Mr. Namasisi was a strong proponent of the view that there was no need for second Audi. I'm asking whether you are aware of that or not.
I did indicate that I remember there was a debate about that. And I also think Mr. Namasisi also made his contributions towards that.
Sorry, I've been asked to.
You are muted. You are muted. Mpofu, you are muted. Or you're not talking to us. Advocate Mpofu.
Thank you, Chair. So no, I'm sorry, I was being alerted to the fact that my personal emails were being displayed. Probably a fault on my side there. Can you hear me now, Chair?
Go ahead, please proceed.
Yeah, thank you, Chair. Yes, that problem has been rectified. Okay, that's fine, Mr. Kekana. Will deal with Mr. Namasisi if and when he comes on those issues. The other point, which and I'm asking you this because you are a legal person who was involved with these things. There was also a view which was held that the so-called 2-year bar that is put in section 69 of the Public Protector Act is a matter that is in the discretion of the PP. In other words, if a report, and let's take the CX report as an example, you know that the CX report related to events that happened in the 90s, correct?
Yes, that's correct.
Yeah, that even though the investigation was on a subject that was more than 2 years old, the public protector, if she felt that this was in the public interest, would have jurisdiction over it. That was another debate among the legal people in the public protector. Are you aware of that?
I remember something like that.
Yes, and that one actually, it was only for the first time it came to before our courts in the matter of Godan, I think the Pillay matter, or either the Pillay matter or the Rogue Unit matter. But again, that was after your time, correct?
I think that's correct.
Yes. Right. In the same vein as I spoke to you about the issue of the DA or any political party, when we went to lunch, you and I were debating about the aspect that was called by the evidence leaders ever comes back. We'll deal with it at that point. But let me put another proposition to you. And I preface it in the same way by saying the public protector will deny the insinuation you were making that she instructed you to remove politicians from the Friday report, you know, for the reasons that you were suggesting.
Chair, as I indicated, I was only informed by Mr. Ndo that we should remove those.
Okay, that's another Mr. Ndo special. Okay, so Mr. Ndo didn't tell you, insofar as any politician were to be removed, as to why that would be so?
I don't remember any reasons being advanced.
Yes.
I remember it being as he indicated, as an instruction.
Yes, but that what I'm saying is that there is the reasons for an instruction or advice or whatever it is. You did not know. There might have been a good reason or a bad reason or an indifferent reason. You don't know.
No, I didn't know.
Yeah. Okay. Now let me ask you the question I asked you, which is a more theoretical one. If, in terms of the investigation, it was clear that the responsibility for certain actions should be leveled at the level of the executive management of government and not at the level of politicians. I'm saying if that was what the evidence was showing, would there be anything wrong with the head of the public protector or the NPA or any institution saying that those persons who are not implicated must be removed? Is it necessary? Is it compulsory to have politicians implicated, even if the evidence might not point that way?
I'm not so sure, Council, which question I should. I think that you have two questions in your proposition.
Okay, answer the last one. Is it compulsory for politicians to be implicated even if there's no evidence?
Well, if there's no evidence, then they shouldn't be implicated.
Yes, and if they are wrongly implicated, well, not just politicians, even you and I, if they mention you in a report and it is clear that you were not directly involved, shouldn't your name be removed?
That's correct. If we find that it was an error on our side to include you, then we would remove it.
Thank you. So the point I'm making, Mr. Kekana, is a simpler one, that, the hullabaloo about the mere act of removal or even insertion, for that matter, is meaningless unless if we know whether there was a good reason for that name to be included or excluded. I'm sure you would agree, just as an investigator, to that general proposition, correct?
Yes, as I indicated, Chair, if there were no findings of any wrongdoing of any individual, then it would be fair only to remove that from the report.
Right. And right, now let's try and be fair on you to ask this. Yes, I was saying in your the Mahashua attorneys, the investigation on you that was being conducted was conducted by attorneys, independent attorneys, correct?
Yes, I was informed that the Mohashua was making some form of investigation.
Yes, and that was around the issue of your alleged, well, it's no longer alleged now, it's true, of your abuse of information, which was, which reached your computer by mistake.
Well, at the time when I learned of the Alemo Khashwa, I didn't know there was an investigation against me.
Okay, fair enough, yeah. Okay, the last thing I want to ask you, Mr. Kekana, is that, let me first put it to you. I'm going to argue at the end that literally anything that you have said should be taken with a pinch of salt, if it should be taken at all. Actually, it should not be accepted at all because you are an unreliable and dishonest witness. What would you say to that?
Chair, I've given evidence to this committee, and it's up to the committee to use that evidence anyway fit.
Yes, and that the only true thing that you have said in this commission, in this committee, is the fact that you did all this and entered into all these affidavits in order to avoid charges being leveled against you, further charges, sorry, being leveled against you. I think there you were telling the truth. That's the only motivation you have in life. Any comment?
Chair, that was not the only truth. I provided all the information to the committee to the best of my knowledge.
And that you knew and you know, as you have now confirmed in your testimony, that the interactions with SSA were deserved because they were the signatories to the CX agreement, and there were those missing transcripts, and that there was nothing untoward with those interactions, as you have now subsequently confirmed, correct?
Chair, I indicated that we needed to interact with the SSA to get a version from them, which we never got.
Yes, and you also, I will also argue that you know, despite all the verbal gymnastics to portray it otherwise, that the meeting with the presidency and not the president, and that one you have confirmed, that meeting was only to deal with the issue of the SIU, because proclamations of the SIU are only dealt with at the level of the presidency. And that was the only issue discussed in your presence in that meeting.
Chair, it wasn't the only issue that was discussed in my present. Yes, I do confirm that we discussed the SIU in regards to the remedial action.
Yes, and Mr. Nemasisi was also part of that meeting, correct?
I'm not so sure. I think he might have come also at a later stage, or I even found him there. I'm not so sure whether he was there.
Yeah, but last year on the 28th of March 2021, you did an affidavit for the police to assist in the prosecution of the public protector, correct?
I remember doing an affidavit, that's correct.
Yes, but you did it to the police to assist them to prosecute the public protector
Sorry?
Yes, among other things, for the unfounded charge that she had met with the president. That's what she was being prosecuted for, and you assisted in that process.
Yes, I was requested to provide an affidavit to the law enforcement agencies.
Yes, anyway, the point I'm making is that you said in that affidavit that Mr. Nemasisi was in the boardroom. Does that assist your memory now?
No, in the affidavit that I have, I don't remember mentioning Mr. Nemasisi.
Does this ring a bell? On 7 June 2017, I was invited to a meeting held at the private office boardroom. When I arrived in the boardroom, I found Advocate Mkoban and two other ladies. Advocate Mkoban introduced me to the two ladies and indicated that the ladies were from the presidency's legal services. I cannot recollect their names. Also present at the boardroom was Mr. Nzumbenzeni Nemasisi, former senior manager at the public protector. Sorry. Yeah, that's important, but I cannot recall whether he joined the meeting after me or whether I found him in the boardroom, which is what you said. In fairness to you. But the question about his presence, you testified to it. In fact,
yes, and I indicated I wasn't that cleared up whether he was there or not. Whether I found him there or not.
Yeah, that I grant you. That's not what I'm talking about. I'm talking about his presence. Yes, Chairperson.
I'm asking you to wrap up now.
Yes, Chair. I promise. It's my last couple of questions.
You said it was your last question, because at least now I've given you further 5 minutes. Please wrap up.
Okay, Chair. No, I said it was my last topic, but I take your point, Chair. I know I've gone past the half an hour that you gave me. Anyway, Mr. Kakana, unfortunately, we can't go through all your inconsistencies. I look forward to seeing you when you come to testify in the criminal proceedings. Thank you.
Thank you very much, Advocate Mpofu. Thank you. That concludes that cross-examination session. Just before I invite and recognize members present here and in the virtual for their own interaction, I'm going to recognize Advocate Bauer, as I indicated that she might have one or two issues she just wants to clarify before members come in. Advocate Bauer?
Yes, Chair. There's 3 issues that I need to raise, and maybe the first one has got to do with this simulated subpoena that was raised by Advocate Mpofu yesterday, and to make sure that there's no suggestion that the evidence leaders was involved in any manner in trying to mimic a subpoena. Endeavors were made to contact Mr. Kekani. He didn't respond to the overtures. Advocate Mayosi sent him an SMS or WhatsApp. On the 23rd of May, she inquired as to whether she could speak to him. He confirmed a time in the late afternoon. When she called, he didn't respond to the phone call. Subsequent to that, a letter was addressed. He indicated he wasn't minded to give evidence before this committee, and I then indicated in which case, given that there was an affidavit in the public domain, we would liaise with the chair for purposes of issuing a subpoena. Subsequent to the issuing of a subpoena, I indicated that we should make contact with him again and see if he was prepared to talk to us. We had a Zoom meeting with him for the first time, which was our first point of contact, Thursday night after our proceedings on the 14th. My opening question was, Mr. Kekana, can you please take us through your evidence? His response to me was, if you want anything from me, ask me questions. We had a short meeting with him then. I then asked him whether we could have a follow-up on Sunday, the 17th, at which stage I sent through and scanned him various documents which I had, which I then also provided to Advocate Mpofu, indicating that I wasn't necessarily going to use it, but because I gave it to Mr. Kekana, I furnished it to Advocate Mpofu. Those same documents as what was item 40 before the committee today, including the handwritten notes which we had in our possession, which did not include the handwritten note of the 3rd of May because we didn't have it. Just to put to rest any suggestion that we may have been complicit in soliciting what Advocate Mpofu referred to as a simulated subpoena. So that was the first issue. The second issue is that there was a newspaper article on the 17th of December 2019 issued by Media 24. That newspaper article is part of Bundle F, item number 39. I had indicated to Advocate Mpofu last week that I was going to refer the committee to the article for the following reason. It's what alerted me to Advocate Mr. Kekani's statement, and that I had made contact with the media company and obtained from them. The article effectively says a senior state security agency official had confirmed pivotal details of a whistleblower's account over the conduct of the public protector. And so I inquired from News 24 what confirmation they had received in respect thereof, and to see whether that confirmation was reflected in the newspaper article. The newspaper article details a number of issues, and News 24 then obliged and provided me with the questions that had been asked of the spokesperson at the SSA on 14th of December 2019 and the responses that they received to that, which for purposes of completion and because I obtained it, I had provided this to Advocate Mpofu on Sunday, and I do owe him an apology. I had told him about it last week and then I couldn't find it. I had mislaid it amongst the hundreds of documents that we had been provided with, and then only sent it to him on Sunday, which is why I didn't raise it yesterday, so that he had an opportunity to look at it. And effectively, one has to look at the questions that was put for James Ramabulana and the answers that was provided by them in that regard. And I'm not, the committee will get a copy of this, but there was, and I don't think this is an issue, that the meetings occurred and that he attended both meetings on the 3rd of May 2017 and 6th of June 2017, and that the minister and Mr. Fraser was present at the 3rd of May 2017. And then the third question is, can you confirm why you were asked to accompany the minister and DG to this meeting? And the response was, it was within the context of a request that the meeting of the 6th of June took place. I indeed attended the meeting of 6 June 2017 as part of a follow-up earlier meeting. I was with Mr. Moodley. And the fourth question is, do you deny that during this meeting, Mr. Moodley, well, some of the answers are joined into that. So he confirmed that he accompanied the minister and the DG and that Mr. Moodley attended. And then question 5 is, do you deny that during this meeting, Mr. Moodley handed the public protector a typed note containing the wording of a recommendation that was to be included in a final report that ordered Parliament to amend the Constitution to effectively nationalize the Reserve Bank? That question was not answered. The next question is, why did you fail to correct the public protector who introduced Mr. Moodley to a staff member as an economist, despite the fact that he was, well, the question is, he are not, as it were, an economist of any kind? And the answer is, I cannot answer why I did not correct the PP when she introduced Mr. Moodley as an economist, as I expected him, Moodley, to do so. In fact, I can't even remember what she said. At the time, he was the advisor to the DG on technical matters and had, for that matter, worked in the economic sector before. For information, he had worked in the banking sector, the Reserve Bank to be specific. But that does not mean that on the day in question, he in my presence wrote the report. I understood his role as that providing the requested technical support case management system. And then the next question was, can you confirm that you were involved in drafting the recommendation? And if not, who assisted you and Mr. Moodley? And that's not answered. And then, was the nationalization of the Reserve Bank a stated project of the State Security Agency or of yourself and a small grouping of senior SSA officials? If not, then why was the SSA involved in drafting a recommendation that had the ultimate effect of amending the Constitution under your leadership? The answer is, as for the SSA, as far as I'm aware, we never had a project on the nationalization on the South African Reserve Bank as insinuated by the media. And the next question is, did you discuss the recommendation, its drafting and act of handing it to the public protector with either Mr. Arthur Fraser or Mr. David Mahlobo? And the answer is no, I was not part of drafting the report in question. My only part was answering questions on the CX report. In fact, I was not familiar with its contents until the media wrote about it. And the last question is, why have you remained silent about your role in handling the recommendation to the public protector during the years of litigation surrounding the report? And the answer is, it is anyhow the mandate and or legislated role of the SSA to advise any government department, state-owned enterprise and public institution, the PP included, on any matter pertaining to national security. It must be noted that national security encompasses / includes political, economic, social, environmental, scientific and technological issues. It must also be noted that the SSA can only advise and recommend to its clients decisions of the sole function of its clients, national, provincial, local government, department and SOEs, including public institutions. And then, okay, so this comes up in the context of the evidence that Mr. Kekana gave as to the events that occurred on the 3rd of May and the 6th of June. And I'm raising it because we do not have the member of the SSA as a witness on our list. We have endeavored to make contact, but there are certain protocols in place for SSA members which we haven't overcome, and we may not necessarily need to in light of this. But given that I did obtain the information, it was only fair that I provided to Advocate Mpofu and put it before the committee. There is one other issue which I neglected to raise earlier on, and Mr. Kakana was asked about having provided a confirmatory affidavit. And so that there is no confusion over the context of the confirmatory affidavit, it is provided. Advocate Mkabani provided a replying affidavit to the Constitutional Court in the proceedings before the Constitutional Court. That replying affidavit is at 11 is 11 sorry, I just want to give you the reference to that. It's at 1829 of the bundle A of the, sorry, no, it isn't. The page, it's 1152 is the reference to Mr. Kikani in that affidavit, where it reads, what was discussed at the meeting of 7 June 2017, and that's the meeting with the presidency, is clear from the handwritten notes taken during the meeting by Mr. Tebogo Kikana, senior investigator who assisted me during the investigation. The handwritten note was disclosed as part of the Rule 53 record and is annexed here to at RA1, which form part of the record. Confirmatory affidavits of Mr. Kikana and Mr. Nemasisi are filed here with. And then the confirmatory affidavit is to be found at 1178. And Mr. Kikana confirms the reply deposed to by Advocate Mkabani and the contents thereof insofar as it relates to him. And I should have drawn that to the committee's attention during his direct examination. Thank you, Chair.
Thank you, Advocate Bauer. Honorable members, I want now to note both from the virtual and physical your readiness to interact. I note Honorable Sukas, followed by Honorable Mailam, followed by Honorable Ngola, followed by Honorable Heron, Honorable Hermans, Honorable Mkweba, Honorable Gondwe, Honorable Lotrit, Honorable Olomisa, Honorable Mulder, you in. Honorable Tseke, Honorable Zungula, Honorable Masaule, Honorable Siabi, Honorable Nodada, Honorable Siwela, Honorable Zagude, Is that all? Honorable Tlape? Any other? How do you know that I didn't call him? Thank you, colleagues. Honorable Maneli. Thank you, General. Those are the hands. Let's kick. Honorable Sukas, you set the scene.
Yes. Thank you, Chair. Mr. Kekana, I just want to ask you 3 questions. And the first is, when you were appointed to the private office of the public protector, would you consider that a promotion? And was it explained to you why you had been approached and not your colleagues? And then I want to know whether the public protector interviewed you prior to your appointment, and what role did she play in appointing you? And did she approve of your appointment? Then lastly, how would you describe your working relationship with the public protector, and did it change? Thank you, Chair.
Did you get those questions, Mr. Kekana?
Chair, could I just have a repeat of the first question?
Okay.
My first question was whether your appointment to the private office, whether you would consider that a promotion, and and if it was explained to you why you had been approached and not your colleagues. Yes.
Go ahead.
Thank you, Chair. The appointment to the private office chair, according to my view, was not a promotion. I was still a senior investigator. No one explained to me, Chair, as to why I was being approached. I was just approached by HR, and they informed me whether I was keen to work with the PP in the private office, and I indicated my keenness. Chair, I was not interviewed for the position. From my understanding, it was a transfer from quality assurance to the private office. On the issue of the working relations with the PP, I would say it started out fine. We had very cordial relations. But I think after the CX report, and when it got challenged, and the ensuing consultations that we had with attorneys, the relationship between her and I became distant, if I may put that, Chair.
You done?
Yes, sir.
Honorable Sukas, any follow-up? Thank you. I proceed. Honorable Mailam.
Thank you, Chairperson. Chairperson, I have 14 questions. Could I ask that they be answered individually? Is that okay?
Come again?
I put a question and he answers, and then I put the next question and he answers. Is that okay?
I don't determine the style of a
Okay.
member.
Thank you, Chair.
But
Mr.
I'm not sure about the number of questions, but
Let's see how it goes, Chair.
the style I don't determine.
Okay, let's see how it goes.
Anything else thereafter I do determine.
Thanks, Chair. Let me
Thank
see
you.
how it
Go
goes.
ahead, Honorable Mailam.
Thank you. Mr. Kekana, could you perhaps tell us why the public protector needs a political advisor?
Chair, I wouldn't be sure about that. That there was never any reason that was advanced to me as to why the PP needed a political advisor.
Just as a follow-up to that, should politics have any influence whatsoever in the investigations or decisions of the public protector?
According to my knowledge, no.
Okay, thank you. What role does a staff member's political affiliation play in the Office of the Public Protector?
Usually it would play no role at all because we would be entrusted as being impartial and doing investigations with integrity.
Thank you. Was there any evidence provided about Ms. Erica Cilliers that she was a DA member?
Not that I'm aware of, Chair.
Thank you. Can you tell us why the Public Protector did not want the Gupta leaks allegations used in the Freda Dairy investigation? And perhaps to contextualize it, if there are allegations, surely it's incumbent on the Public Protector to investigate them.
As I indicated, I was just told by Mr. Ndo that we should not follow that. And I have indicated that I did not get any reasons why we should not follow that lead.
On the same topic, do you agree that the Public Protector's decision to narrow the scope of the Freda Dairy report or investigation was irrational? And I'm going to quote from the court in the DA versus Public Protector case, as it sidestepped all the crucial aspects regarding the complaints and led to a failure on her part to execute her constitutional duty. Do you agree with that statement?
I have a view, Chair, that in us drastically amending or reviewing that report where we took out most of the information, it wasn't the right thing to do.
Thank you, Mr. Kekana. Had politicians been implicated and or had adverse findings against them prior to the Freda Dairy report? And if so, were their names removed from those other reports?
Chair, my memory, I remember seeing draft reports or a draft report with some form of finding against political office bearers.
Okay. Were their names removed?
Chair, from our report, we did remove the, I don't think our report had such findings, but I remember previous reports had such findings, and in our report, we did remove anything that was negative towards the political office bearers.
Okay. You spoke about the meeting, and there's been a lot of discussion around the meeting that was held at the State Security Agency. Is it normal for the minister in any department to be present when the Public Protector does an investigation at their department?
Yes, sometimes we do have ministers attending such investigative meetings. And maybe just to correct that, Chair, we didn't have a meeting at the SSA. We had a meeting at the Public Protector's office.
Thank you for that correction. Mr. Kekana, with regard to the email from yourself to Mr. Goodson, the full sentence in that email reads, "The Public Protector wishes to meet with you." Now, my question to you is it your opinion reflected on that email, or was it the view of the Public Protector that Mr. Goodson had extensive knowledge of the South African Reserve Bank and central banks in general?
The Public Protector had always wanted, or was the one that wanted to meet with Mr. Gupta. And I believe she had a view that he would be, he would be useful in our investigation.
Thank you. In Report 8 of 2017, in clause 7.2.1, it says, that particular paragraph refers to the remedial action proposing amending the Constitution. Was that the clause that the Public Protector requested or instructed you to insert?
Through you, Chair, let me just have a look at the paragraph, Chair. Can I be repeated?
7.2.1? 7.2.1.
Yes, what was the question again, Chair?
So my question was that the sentence that or the paragraph that the public protector instructed you to insert about amending the constitution?
That's correct.
Why did you find amending the proposal to amend, or the remedial action to amend the constitution, why did you find that, and to use your word, bizarre?
Well, according to me, it was irrelevant to the investigation. That's why I found it bizarre.
My last question is this. Is it normal for other departments who are involved in an investigation to provide the wording for a remedial action, or for members of such a department to do so?
According to my experience at the Office of the Public Protector, it was the first time experiencing that. And for me, it was not normal.
Thank you very much.
Thank you. You've just met my limit, just about there.
Thank you, Chair.
Thank you, Honorable Mailam. Honorable Ngola.
Thank you very much, Chair. I hope Mr. Kekane did get lunch. It looks like he will need energy. Chair, I've just few questions which are emanating in majority from the affidavit deposed by Mr. Kekana. Mr. Kekana, Chair, alleges that in the CX report, a provisional report was leaked. Having been leaked, it was indeed, as the series of statements is making in the affidavit, it was perhaps in the hands of himself, Ms. Mahlawe, and is it Mr. Mahlawe? Mr. Mahlawe and the public protector. But that information got leaked. It had material errors. It was not subjected to quality assurance as the provisional report. Has there been an investigation summoned by the Office of the Public Protector or the Public Protector to investigate how did that provisional report get leaked, so that the office is able to prevent further leaks?
Chair, if I remember well, I was told of the leak by the public protector. And if I remember well, I think the public protector did make a report to the law enforcement agencies in regards to that. Chair, I'm not aware whether there was an internal investigation at the Office of the Public Protector relating to the leak.
As an investigator and a report writer of the office, in the private office of the public protector, should you have been made aware if there has ever been any investigation summoned by the office to the leak, or any investigation done by law enforcement agencies as the person who was responsible for the leaked provisional report? Was it not expected that you should be made aware if there is any of investigation, whether internal or external?
Chair, as I indicated, I was made aware of the leak, and if I remember correctly, I think the PP did report this matter to law enforcement agencies. So I was made aware of the leak of the preliminary report or provisional report.
Okay. Fine, let's leave that. In the affidavit you deposed, there was a meeting with the Black First Land First movement, which discussed the provisional report. whom you say in the affidavit, it was said that they can't be a complainant in the matter. But you continue and say, however, Advocate Mkwebane invited the BLF to make submissions on the investigation, that the BLF was in no way involved in the matters pertaining to the investigation or any other relevant matter. If the PP allowed the Black First Land First movement to be part or submit any issue as pertaining to this report, who is this person who said they can't be complainants in this matter?
Chair, the PP did indicate to the BLF that they couldn't be complainants in the matter.
But they were later allowed to.
Yes, yes, Chair, I do confirm that they were allowed to give inputs.
Okay. Then let's go to what you term as a private meeting or a meeting before the meeting you are supposed to have set with it, with SAA and SSA and the Public Protector South Africa. You mentioned that before that meeting resumed, you were shocked by a meeting before the actual meeting between the Minister of SSA, Honorable David Mahlobo, and the Public Protector. In the time when you served in the private office of the Public Protector, has it ever happened before, or it was the first and the last meeting that set before the actual meeting?
That was the only incident that I observed.
Okay. You say there is a meeting where the Public Protector actually instructed you not to record or take minutes, or else you are prohibited from taking minutes or recording that meeting. Were there any reasons provided to you as a person who usually records and take minutes of meetings between departments and the Public Protector?
No, Chair, I wasn't given reasons as to why I could not record.
Thank you. Apart from, let's go to the South African Reserve Bank constitutional amendment matter. You have answered from Advocate Mpofu and Honorable Milam that you believe strongly that the amendment of the Constitution, as it was suggested by the report, was actually irrelevant from the investigation you conducted on the Reserve Bank Bancorp matter.
Yes, that's correct, Chair.
Yes. Now, I want to check that. Do you think that it falls fully in the powers and the jurisdiction of the Office of the Public Protector to suggest such kind of a major amendment in the supreme law of the country?
Chair, according to my view, I don't think so.
Okay. In paragraph 34 in your affidavit, you say you learned that the Public Protector has appointed new attorneys and counsels. In your experience as the person who closely was working with the Public Protector, what is the process of appointing or hiring legal counsels and attorneys?
Chair, I wasn't privy of that process. That process was being handled by our legal services unit. So I wouldn't be aware, Chair, of the process of appointments and terminations of attorneys and counsels.
Thank you. In paragraph 42, you allege that Advocate Mkwebana did not care if the reports were taken on review or not. Do you mind if you can elaborate a little bit on that?
Chair, what I remember is that while we were going through the report, taking out information, Mr. Namasisi did warn the public protector that removing such information could lead to a review. And I remember the statement that she made that she didn't care whether the report would be reviewed or not.
Thank you. The last question, Chair. It's the last, I promise. Did the South African Reserve Bank ask the Office of the Public Protector that it be finished with the report before it being published? If the answer is in the affirmative, has that request been adhered to? And the last would be, what is the general procedure in terms of your reports? Should there be not consultation of the affected persons before the issuing of the final report?
Thank you. Go ahead, Mr. Kekane. That's the last question from the member.
Thank you, Chair. I'm just jotting it down. Chair, can I just get clarity to the adherence to meetings, Chair?
Yes, can you make it precise, Honorable Ngola?
I'm saying, has there been a request from the South African Reserve Bank that the Public Protector South Africa should finish it with the provisional report before the final report is issued? Has there been adherence to that? And what is the general procedure?
Chair, I on the score of the meeting with the South African Reserve Bank before the report is publicized. I don't recall, but I think there was correspondence from the Reserve Bank about the meeting, but Chair, I don't clearly recall unless I'm shown a document which will refresh my memory. And Chair, in regards to consulting before the issuance of a report, Chair, my understanding is that if there were no significant changes, especially emanating from our Section 9 notices and our preliminary report, then we would not consult with the affected parties. But if after issuing the notices and or the preliminary report, and we have significant changes to it, the right thing to do would be to consult with the affected parties on those changes that have been made, because we hadn't put it to them, those changes. So it would be proper to consult with them on the changes.
Was the proposal for the amendment?
Thank you. There's no follow-up there. Thank you. You've reached my limit. If I have a gap at the end, we'll do that. Honorable Heron.
Thank you, Chairperson. Chairperson, I also have one or two questions for the Public Protector. We're going to do it as we did once the previous time. So at the end, thank you. Mr. Kekane, I want to just go back to the time when you were removed from the private office of the Public Protector. And you say in your affidavit at paragraph 37 that, and I think you've said it in evidence too, that it was because you were saying too much to lawyers representing the Public Protector in the review proceedings. So was this about your previous evidence in your affidavit and orally that the public protector's recommendation came from the SSA, and things like previous drafts of the reports should not be included in the review bundle, in other words, in the Rule 53 documents. Is that what you're referring to when you say too much to lawyers?
Chair, I did not get any reasons, but I did suspect that it related to that.
Mr. Kakana says, I was told that it was because Advocate Mkhwebane was of the opinion that I say too much to lawyers. So is that wrong?
No, that I'm saying that that's correct. I was told that the PP said I was talking too much to attorneys, but I'm not so sure on which subject matters I was talking too much to the attorneys. I suspect that it might have been the issues on the SSA.
Thank you. When you were appointed as the lead investigator on the Freda Dairy project after the removal of Miss Erica Cilliers, when was that?
Sure. I was also trying to, resuscitate my memory on when we were allocated that matter, but I just couldn't find the time period or when specifically we were allocated that matter.
But were you still in the office of the private office of the public protector, or had you then been moved to the provincial integration unit?
Yes, and Chair, that's my problem as well. I don't remember because in December of 2017, that's when I was transferred to provincial investigation and integration. I really don't remember when this matter was allocated to us.
So about us, I'm trying to understand whether you were in the private office of the public protector when you were first appointed the lead investigator of the Freda Dairy project, or whether it was after you were moved from the private office.
Yes, Chair, that's where I'm struggling with my memory, Chair. If I would find a date, then I could confirm whether I was in the private office or whether I was in provincial investigations and integration. But my memory is failing me on that.
But in any event, Mr. Kakana, you continued to work on the Freda Dairy project after being removed from the private office of the public protector.
That's correct, Chair.
And you said that Mr. Indo informed you that, or instructed you that you should not include any finding against any politician. Is that correct?
That's correct, Chair.
Was that before the meeting on the 8th of February 2018 when you met directly with the public protector and the manager of legal services?
Chair, is the question done or?
Yes, sorry, it's done.
If I remember well, it was before the meeting on the 8th.
So at the meeting of the 8th of February, you say in your affidavit at paragraph 42, the advocate Mkhwebane instructed you to remove material information relating to the investigation, including information relating to the inflation of goods and information relating to beneficiaries. But she wasn't referring to any political politicians in that meeting?
I think in that meeting, there was no reference to that because in that meeting, maybe let me take you a step back. At paragraph 41, I do state that Mr. Ndo from PP's instruction told us that we should remove any adverse findings against the politicians. On the meeting of the 8th of February 2018, Mr. Ndo was not present in that meeting. So we were told to remove those adverse findings before that meeting occurred, not in that meeting.
If I may just move on, Mr. Kekana, to the meeting with the that the minister had with the public protector privately. Can you just sketch the scene? How did you know that the meeting was private between the minister and the public protector? Were you waiting outside in a waiting room and you saw the two of them come out of the meeting? Or, I mean, how did you know that there was no one else in that meeting?
If I remember well, I did go to the private office when I was alerted that the meeting would begin. I think there was also a time for that meeting. So when I arrived at the private office, I don't remember who told me, but that person indicated to me that there was a meeting between the minister and the PP and that I should wait.
So did someone tell you that there was no one else present, or you saw that there was no one else present?
I think when they came out, that's when I noticed, because yeah, when they came out, that's when I noticed that it was just the two of them.
Okay. Can we move on to the part when you do attend the meeting and you instructed not to record the meeting and also not to take notes? And as we've seen today, you did actually take some notes. What happened to those notes after you took them?
After I took those notes, I just put them in my file.
So they were then in the file, and then that's how they were included in the Rule 53 discovery documentation.
I would assume so, yes, that's correct.
Can we just refer to TK3, which is the email that the public protector sent you, in which she says, I'll go through it and we will meet to finalize, ask the SSA to provide input and economist, which you say was inexplicably excluded from the Rule 53 discovery and was never disclosed until now, which is obviously when you've deposed to your affidavit in December 2019. How did you manage to disclose it in December 2019 if it was written in 2017 and your emails, particularly your emails between yourself and Advocate Enquiry, were removed from your laptop?
Chair, I did print it out on the Mimecast application. I think it's an application that's used to back up emails. It was one of the emails that I fortunately found on Mimecast, but some of the other emails were not there.
So did you retrieve it then in August 2019? Is that correct? When you got your laptop back, sorry.
I'm not so sure when I retrieved it, but I did notice that some of the emails from the PP on Mimecast were there, and this was one of the emails that was there.
Okay. I just have two more short questions, Chair. Mr. Kakane, when you were asked by the public protector in May 2017 to run it past a third person, and then she suggests Mr. Matlawe. Did you send it to Mr. Matlawe for the third eye or another eye to look at it, the draft report?
Yes, if I had received those instructions, I would have carried them out. So naturally, I think, or I believe that I would have sent that email or the draft to Mr. Matlawe.
And then on the 17th of June, when you wrote back to the public protector and you said, unfortunately, Matlawe not here, would that have been that you sent the report to Mr. Matlawe for his third eye to look over it, or the third person to look over it? Then you were to receive it back from Mr. Matlawe after he had checked it or polished, quality assured it or looked at it, and then you submitted it to the public protector. What does it mean by Mr. Matlawe was not here? Was he, I mean, you sent it and you didn't get it back, or I don't understand that.
The meaning, Chair, of Mr. Matlawe is not here. I think maybe I was meaning that he was not present at the workplace at the time. But maybe just to give more clarity, the draft on May 2017 and the final report on June 2017, these were two different documents. The one in May, it was just a draft which was still incomplete, but the one in June was, if I call it, a complete final draft.
Now, I think we understand that, Mr. Kekane, but because it was an iterative process. You drafted, it was redrafted. It was the public protector's instruction was that you send it to Mr. Matlawe for a third eye or another person to look at it before it was finalized. So when you sent the report on the 17th of June to the public protector, it had come back from Mr. Matlawe after he had looked at it. Am I correct?
I think in May, when I was instructed to do so, I did give it to Mr. Matlawe. I'm not so sure whether I received it back. My memory would need to be refreshed on that. But also on the final draft, that was now around 17 June 2017, I was also supposed to send that one also to Mr. Matlawe, but he was not available at work.
But in your affidavit,
That must be your last take on the
I wasn't expecting to have to do follow-ups within this, but it will be my last. I'm just trying to understand, in your affidavit, you say that you mentioned to Mr. Matlawe that the document, the report was released, and he was taken aback. So I'm really struggling to understand. You sent it to Mr. Matlawe, you say you followed that instruction, you received the report back, you assume, then the report was released and he's taken aback that he never got to see it.
Yes, so usually the final report, that would be the draft, the final draft around June 2017. That draft or the final draft was supposed to be sent to Mr. Matlawe and he could not be found on that day. So I did indicate to him that the report was never QA'd, and he was taken aback by that suggestion.
Can I just wrap up, Chair? Can I, Mr. Kekane, the report that you sent on the 17th of June to the public protector as the final draft, was it the same report that was published on the 19th of June, 2 days later? Thank you.
I think more or less it was the same report. Because what I remember is that because Matlawe was not there, and I did indicate to the PP that Matlawe was not there, she then did her own quality assurance of the final report, and then she signed it on the 19th, I think.
So, Mr. Kekane, the report that was released on the 19th of June was, as you say, more or less the report that you wrote.
That's right.
Thank you.
Thank you. Thank you, Honorable Heron, and thank you, Mr. Kekane. It's just 15:32 now. We'll take a 15-minute break. When we come back, I will invite Honorable Hermans to take the stand. A tea break. Back in 15 minutes, colleagues. Thank you.
Thank you, Chair.
Recording stopped.
Chair, no, I wasn't involved at all in the drafting or the publication of the provisional report. I remember, Chair, at that stage, I was not involved in also the investigation there.
So what, in your opinion, was the motive for the removal of the information that was omitted, that was removed from the report? In your opinion?
Chair, does that refer to the information about Mr. Billy Masehla?
The information that was removed from the report, that was omitted.
That was omitted from the CX report. I don't understand, Chair.
Is it Freda Dairy or
No, no,
CX?
the CX report.
Okay.
If you go to paragraph 17, which refers to Mr. Billy Masehla, yes.
Yes, I'm not so sure why and how these documents relating to Mr. Billy Masehla were missing.
Then also my next question relates to the Vrede Dairy project. I know Honorable Milam has asked you about it already in paragraph 14. Can you just tell us whether the public protector provided any reasons why the Gupta leaks should not be used in the investigation or included in the report?
Actually, we never got any reasons as to why we shouldn't follow the Gupta leaks.
And the omission, or whether it should be included in the report. You didn't get any reasons from the public protector.
Yes, Chair, we didn't get that. We were just informed by Mr. Ndo that we should not follow the lead involving the Gupta leaks.
Okay, and you did not raise any query in that regard?
No, Chair, we didn't.
Thank you very much, Chair.
Thank you, Honorable Hermans. I now recognize Honorable Mgweba.
Thank you very much, Chair, and good afternoon, honorable members. Mr. Kekana, on the CX investigation on paragraph 15, you have indicated of the public protector provisional report leaked. Since you have started employment with the Office of the Public Protector in 2011, was it the common practice for some provisional report to be leaked, or was it the only report leaked?
If I remember, I think this was I think for me, it was the first time that I hear that the provisional report was leaked. I'm not so sure whether there was any other report that was leaked. My memory is not serving me right on that one, Chair. But I think it was one of the incidences which I experienced that the report was leaked.
Thank you, Chair. And Mr. Kekana, you have stated in your affidavit on paragraph 54, open quote, it therefore appears that the purpose of the precautionary suspension is to punish, to harass and victimize me as a result of me raising concerns of maladministration within the Office of the Public Protector. Can you please elaborate further? And secondly, to whom did you raise these concerns? Thank you very much, Chair.
Chair, to me, the way that the precautionary suspension happened, I felt that the process that was ensued was not a fair one, and I also suspected, Chair, that because I was raising issues of maladministration within the office through the union, that might be why I was put on suspension, Chair.
You have not responded to the last question. To whom did you raise these concerns?
Oh, I did raise the concerns, Chair, to the PSA, the union chair.
Thank you, Honorable Weber. I now recognize Honorable Gondwe.
Chairperson. Chairperson, can I ask that?
I can't hear you.
Chairperson. Can I ask that I ask him questions and then he can answer them afterwards? I just want to.
You want to throw your question and then he
Yes,
can.
I don't want the camera on.
That's fine. What we'll do was to make sure before he responds if he got all your questions.
Yes, that will be proper.
Go ahead.
Dumela Rekakana, is that okay? Can I ask you the questions and then you respond to them, not one by one, but after you've gotten wind of what I'm asking?
Chair, through you, I don't have an issue with that.
Okay, Kalebo. Rekakana, my first question is around the complaint that was initially lodged with the Office of the Public Protector in relation to the CS investigation. Who was the subject matter or focus of the investigation? Was it CX? Was it SSA? Was it Bangkok? And when the investigation was revisited under the auspices of Advocate Mkhwebane, did the subject matter or focus of the investigation remain the same or did it change? Can I proceed with the second one?
Yes, please.
With respect to the Black Land First, the organization, you submitted in your oral evidence that it was not allowed to come in as a complainant, but it was allowed to make submissions or inputs. Do you recall what those submissions or inputs were and if they bore any relevance to the investigation?
Thank you. Got that. Proceed.
My third question is that you stated in your oral evidence before the committee that during the meeting with the SSA, you do not recall there being a discussion on the vulnerability of the Rand and the Reserve Bank, but there were discussions rather on the Reserve Bank and the fact that it was prone to looting and its vulnerability during the apartheid era. Can you confirm what these discussions were based on? Were they based on the book by Mr. Goodson or on the comparative research articles that you made reference to in the course of your oral evidence? The next question also relates to the meeting with the SSA. You stated in your oral evidence before the committee that in your view, the meeting was an investigative meeting and you had prepared, and as such you had prepared questions that the public protector could ask in relation to the investigation, in lieu of the meeting with the SSA. Do you recall how many questions you prepared in this regard? Did you email these questions to her? Do you recall what some of those questions were that you prepared? And if you have recollection of any of this, can you share it with the committee, please? You also stated in your oral evidence before the committee that you took the view that the recommendation that the South African Reserve Bank be nationalized and the Constitution amended rather, that you took the view that such a recommendation was irrelevant to the report. Can you explain to us why you took this view that such a recommendation was irrelevant to the report? And we just want you to take us into your confidence around why you took this view, because you've mentioned it on more than one occasion in the course of your oral evidence.
don't forget to continue raising your voice.
Okay, I'll do that, Chairperson. And then again, in your oral evidence before the committee, you stated that several draft reports, were penned before the final report was released, and none of them contained the amendment. Rather, none of them contained the recommendation to amend the Constitution. Can you tell us what sort of recommendations were contained in the draft reports? Again, in your oral evidence before the committee, and just touching on what was raised by Honorable Mgweba around the leaking of the preliminary report. Do you perhaps know how and when this report was leaked, and in whose possession the report was, in before it was leaked? My next set of questions relates to the FREDA investigation. The first set of questions I forgot to mention related to the CX investigation. In paragraph 40 of your affidavit, you state that the public protector issued an instruction that the Gupta leaks emails should not be used in the FREDA investigation. Please confirm if she issued this particular instruction to you personally, or whether it was one of those instructions that was issued via Mr. Ndo, because you mentioned that Mr. Ndo informed you that she had also issued an instruction that you should not make any findings against any politicians and not make any adverse findings against any politician, including the former premier of the Free State and the former MEC of agriculture. So I want to find out whether this, because there were 3 sets of instructions issued in this regard, and I just want to confirm whether that first instruction was issued to you personally, or it was also issued via Ndatendo. My second question around the FREDA investigation is, did you make adverse findings against politicians? Do you recall what those adverse findings were and who the implicated politicians were in this regard? In other words, did the Office of the Public Protector make adverse findings because you were instructed not to make adverse findings? So I'm trying to figure out whether there were any adverse findings made in the first place. And then when in responding to this question, please indicate what those findings were and who those findings were made against, and whether they involved politicians, and if possible, state which politicians. My last question, Chairperson, you stated in the oral evidence before the committee that there was a collective effort to remove the adverse findings, which resulted in the issue of the inflated goods being removed and the information relating to beneficiaries also being removed. Please explain what you mean by there was a collective effort, and who was involved in that, in making that collective effort in removing the findings. Chairperson.
Thank you, Honorable Gondwe. Mr. Kekana, please respond one by one to all of those questions. Your platform is yours.
Thank you, Chair. Through you, Chair, I hope I've captured all the questions right. Chair, in regards to the first question, Chair, the focus of the investigation was on the South African Reserve Bank, the South African government, the SSA, and ABSA, and whether the focus changed. In regards to the parties, the focus, it did not change, but there were issues of nationalization and amendment of the Constitution, which were new matters which I could ascribe as a change. Chair, in regards to the BLF, Chair, I I don't recall what the BLF inputs were specifically, but Chair, I think I remember that I never used any of their inputs in the report, if memory serves me right, because I didn't think they were relevant to the investigation, Chair. Chair, on the meeting with the SSA relating to the discussion of the vulnerability of the South African Reserve Bank during the apartheid era, I'm not really sure what those documents were based on. They were certainly not based on Mr. Stephen Goodson's book, but I just don't know what those discussions emanated from. Chair, again, in regards to the meeting with the SSA, I did prepare a pack of questions for the public protector. I don't specifically remember how many questions were there, Chair, but I had a number of pages with questions. And I'm afraid I'm not in possession of that, Chair. That's I can't share those questions, Chair. I don't also specifically remember the types of questions they were, but I would suspect they would involve their role in the investigation, Chair. Chair, my notion as to why I viewed the issue of nationalization and amendment being irrelevant, Chair, was that Chair, our issues relating to the investigation, Chair, were primarily around the jurisdiction of the public protector, whether the South African government entered into an agreement with CX, whether the South African government failed to implement the CX report, and whether the South African government and SAP failed to recover monies owed by APSA, Chair. That's why, Chair, I am of the view that the issues revolving around the nationalization and amendment of the Constitution were irrelevant according to my view. Chair, in regards to the draft reports, I think this is in regards to the Freda report, Chair. I think, Chair, in one of the draft reports that I saw, there were findings around political office bearers. And those findings, Chair, related to, if I remember, I can't specifically remember the specific findings in those drafts, but I remember, Chair, that the political office bearers knew about the irregularities that were happening in the project. Chair, on the leaking of the provisional report, Chair, Chair, I learned about the leaking of the provisional report in January 2017 when I was informed by the public protector. From my knowledge, I knew that the previous investigator who was working in the private office was working on that matter with the public protector. So from my knowledge, Chair, those two individuals were the ones that were working on the provisional report. In regards to the instructions, Chair, relating to the Gupta leaks, Chair, and again relating to findings against politicians, Chair, we only got the instructions from Mr. Ndo, and those instructions never came personally from the PP. I think the last question was the collective effort to remove things in the report and who was involved in that. In that meeting of the 8th of February, the people who were involved in the removal was in that meeting, or who were there, was the PP, Mr. Nemasisi, Mr. Ndichenerai Dani, Mr. Muntu Sitole, and myself. Chair, I'm not so sure whether I captured all the questions. If I haven't, I would like to request to be directed to one that I've missed, if I've missed any, and I will provide an answer.
No, thank you, Mr. Kekane. I will check, but I'll make sure that she doesn't smuggle any other question besides the ones that you've missed. I'm very alert to that.
I'm not going to smuggle anything, Chair. Rekakana, I asked if you remember, for you to be able to remove those adverse findings, they must have been, contained somewhere. So my question was, what were those adverse findings? Did you make them? So I'm not entirely sure whether you answered that in your response.
So you're asking the actual adverse findings that were made, and that's in relation to the Freda dairy?
Yes, in relation to the Freda investigation.
Thank you.
Because he said that there was a collective effort to remove those adverse findings. So you cannot remove them unless they exist, unless they're made, right?
Thank you, Honorable. Mr. Kekana?
Yes, Chair. As I indicated, Chair, in the previous drafts that we had, and especially remember, Chair, that the file came from the Free State office. So in the reports or draft reports that we had, I believe that there were adverse findings made against certain politicians, and those findings mostly, I can't remember the specific findings, but what I remember is that those political office bearers knew about the irregularities that were happening in the Freda project.
Okay, we'll leave it there. Thank you. I now recognize Honorable Lothridge.
Thank you, Chairperson, and good afternoon, Mr. Kekana. Now, quite a number of my questions have already been asked, so there are only a few remaining. I'm going to ask the question and then request you to reply. Now, we have looked at the issue of the meeting with SSA and the questions that you prepared. Was it standard practice that you would prepare questions for the public protector before any such kind of meeting?
Yes, Chair. According to my knowledge, that was standard practice.
And was this the first time, or had there been other instances when your questions were not used?
Chair, that was the first time my questions were not used, Chair.
Thank you. Then also in terms of standard practice procedure, in your evidence, you refer to the handing over of your laptop. to a firm of attorneys. Was that standard practice? Has it happened before that laptops of investigators, a senior investigator, is handed to a third party?
No, Chair, that was never standard procedure.
Do you have any knowledge whether this particular firm had any security clearance?
Chair, I didn't have any knowledge of that, and that was one of the issues I did raise with the employer as to whether this firm has security clearance or not.
To your knowledge, was the laptop accessed in the presence of anyone from the Office of the Public Protector?
Chair, I don't have knowledge of that.
Thank you very much. Mr. Kekana, if we now turn to, well, I'm hesitant to call it experts, but the economists. Now, in your investigations and your experience since 2011 at the Office of the Public Protector, how is it determined which persons would be considered to be, for example, an economist or someone who could provide valuable information? Is there an operating procedure, a policy to do that?
I'm not aware of that procedure, but I would think that if someone was requested or required to assist the public protector, it would go through a formal process of getting, maybe going through procurement processes, or maybe the public protector could maybe motivate for such. But it would be well known beforehand that we require such an expert on a particular field. I remember in my investigations when I needed experts, maybe engineers, I give that example because I did request for an expert in one of the investigations. One had to go through the procurement process.
Thank you. Mr. Kekana, I now want to go to the recommendation to review or amend the Constitution. This has been discussed earlier in your testimony. And if I look at Section 224 of the Constitution, it states clearly that the primary object of the South African Reserve Bank is to protect the value of the currency. Now, if I look at what we have been presented with and the proposal for a recommendation, that is quite a dramatic move from protection of the currency to promotion. And I would like to know, because this morning we were also introduced to the document by Niels van der Merwe. Now, in relation to that, before I go further on the actual amendment, proposed amendment, who requested or instructed Niels van der Merwe to do this comparative study?
I think the PP did that because I was not in a position to instruct Advocate Niels van der Merwe because he was my senior at the time.
Thank you. And in this document, and I also asked this morning whether this is the full document that we have at our disposal, I can only find two proposals and only one referring to Section 224 of the Constitution, and that is to be reviewed to ensure, that is a 3.9, that as an organ of state, the Reserve Bank is accountable to Parliament to ensure that it implements its powers in a legitimate manner while at all the time maintaining the important independence of the bank. And a bit higher up in this comparative study at 3.7, It is also noted that an independent central bank is a better guarantee of the value of the currency and thus of a generally sound economic basis for the state's budgetary policies. Now, I cannot really find this in the proposed recommendation in terms of changing 224 to go from protection of the currency to actually remove that. So in your opinion, Mr. Kekana, did the public protector rely on this comparative study done on her, as you say, possibly her instruction, to draft that recommendation?
Through you, Chair, I'm not so sure. I'm also not so sure whether this information from Advocate Niels van der Merwe came before we publicized the final report or after we publicized the final report. I'm not so sure whether it also influenced the proposal to amend the constitution, because I'm really not so sure or recall what was Neil's brief in regard to drafting this comparative study.
Okay, thank you. I see that the front page does indicate that these would be the actual principles applicable to the independence and governance of the South African Reserve Bank and proposals for the review of sections 223 to 225 of the Constitution. So I think that would have been the brief. But let's leave it there. Mr. Kekana, I just want to, for my own clarity and to make sure that I heard you correctly, in terms of this recommendation to amend the Constitution, was your evidence earlier, I think on one of the questions, that it was not informed by the books of Stephen Goodson? Did I hear correctly?
Yes, this amendment that we received came straight from the SSA. The amendment or the note on TK4, Mr. Goodson never made any input on it. It came directly from the SSA.
Thank you very much. Thank you, Chairperson.
Thank you, Honorable Lothridge. I now recognize Honorable Lomisa.
Thank you, Chairperson. Colleagues, Mr. Kekana, on a number of occasions, when Advocate Mpofu asked you questions, you kept on saying you don't remember. The question is, do you think the evidence leader gave you enough time to prepare for your appearance before this committee? If the answer is not in the affirmative, would you wish to be given more time to respond in writing to areas you said you don't remember? Lastly, my question is directed to the evidence leader. Are you planning to call some of the people who attended meetings with the public protector, especially on Reserve Bank related discussions, so that we can hear both sides? We have heard his version, but it is important that since he was not working alone with the public protector, sometimes you hear some names being mentioned. We would like you to respond on that. Thank you very much, Chair.
Thank you, Honorable Lomisa. Maybe let's start with Mr. Kekana. You got that question?
Yes, Chair, I got that question. Chair, through you, Chair, it must be emphasized that I really didn't want to come and testify to the commission or to the committee. And one of the reasons that I did advance, Chair, was that my memory in regards to certain events, and especially of events that had happened some time ago, was impaired. Chair, I don't think under the circumstances, I was given time or more time to prepare for the discourse that we've having the past 2 days, Chair. But Chair, I believe that I have answered all the questions to the best of what I could remember, Chair. If maybe I could have been provided with documents or emails from the Public Protector's Office, I think I could have contributed more, especially on the things that I couldn't recollect on, Chair.
Thank you. Any follow-up on him? Thank you, Mr. Lomisa. Advocate Bauer.
We have endeavored to be guided by the motion in respect of the evidence we are calling. And if the member's question is, are we going to be calling some of the names that have been referred to today? That is our intent.
Thank you. Bambile Mkulu. Thank you. Thank you. I now recognize Honorable Mulder.
Thank you, Chairperson. Through you, I've been covered to a certain extent by some of the questions asked by some of the colleagues, but I've got 6 questions for Mr. Kekane. I think they are straightforward questions. I think the answers could also be short and brief. I want to start off by this, dealing with the same point that General Holomisa just now made. During your cross-examination, Advocate Mpofu wanted the committee to believe that we should not give any value to your testimony because, as he put it, because of your impaired memory. Now, your evidence in main was basically based on your affidavit, which was drawn up about 3 years ago. Am I correct if I say that obviously your memory must have been much better because 3 years ago when you drafted the affidavit, it was much closer to the events? Secondly, in the same vein, many of the things that you were questioned about are things that happened more than 5 years ago. And am I correct to say that probably most of the members of the committee, as well as most members of the bar, won't be able to recollect what's in emails of 5 years ago without having the privilege to go through them again and to refresh your memory? Am I correct?
Chair, that would be correct.
Thank you, Chairperson. The second question I would like to ask you is, you were making the point that the SSA was involved in the formulation of the constitutional amendment. And then Advocate Mpofu went through a whole process to convince the committee differently, and he was asking you all kinds of questions about the need that there was a study done, a comparative study in terms of other economic models, etc., etc. And then he referred to what he called your theory. That was his words, your theory. Now, I want to ask you, in paragraph 26 of your founding affidavit, you say the following: on or around 6 June 27, I attended a meeting with Advocate Nkobwane and representatives from SSA, namely Mr. Moodley and Mr. James Ramabulane. And then you go on in the next paragraph, and you say the following in paragraph 27. During the meeting, Mr. Moodley produced a single page which contained a draft of the proposed recommendations which were to be inserted into the final report. in terms of your recollection, in terms of how you worded this in the affidavit, would you say that that is a theory, or is that something that you personally experienced because you were there when this happened?
Chair, I would like to put it as an experience rather than a theory.
You were there. It's not a theory. You were there.
I was there, Chair.
Thank you, Mr. Kekane. Thirdly, Chairperson, Mr. Mpofu tried to make the point throughout during cross-examination that it was absolutely normal for the SSA to interact with the public protector because of a contract that was signed between the SSA and CX. And because of that, it was absolutely normal that there should be interaction between the SSA and the public protector's office. Would you agree that there's a huge difference between interacting with a company like CX that investigated possible misappropriation of funds on the one hand, and on the other hand, where SSA provides the exact wording to change the core mandate of the Reserve Bank as a proposal in the Constitution? Would you agree that there's a complete difference between interacting in terms of the normal contract where there was an investigation up to the point where the Public Protector's Office interacts with SSA and a specific wording of amendment of the Constitution comes out of that process?
I agree there is a difference.
Thank you, Mr. Kekane. My fourth question, it deals with paragraph 25, where you refer to TK3, and that is a document which did not form part of the Rule 53 proceedings, the record. And Advocate Mpofu tried to make the point that you were responsible for providing that record, and if that specific email from the SSA was not in that record, is Mr. Kekane still on the system, Chair?
Yes, I'm still here, Chair.
Thank you. Advocate Mpofu made the point that if that specific email from SSA was not in the Rule 53 record, it's because you didn't put it there. I want to ask you the following. Is it possible that somebody in the office who may have had access to the file could have removed that specific email before you put the record together? And it's not a question of it could be any of 60 million South Africans. It needed to be somebody in the Public Protector's Office. Is that a possibility?
Chair, I think on what I testified on was that I did give the complete file or record of the investigation to Mr. Namasisi. Or what happened thereafter, Chair, I'm not so sure. There could have been a possibility, but I couldn't attest to that, Chair.
Thank you. My fifth question, Chairperson, to Mr. Kekane is the following. Mr. Mpofu made a point on a number of occasions that it's absolutely normal that people sometimes make suggestions and proposals in terms of amendments of the Constitution. And by arguing that, he argued to say, but the fact that the Public Protector did the same is an absolute normal thing, it's nothing strange, etc. However, we all know that when it comes to remedial action of the Public Protector, everyone is bound by that remedial action, and you have to comply with that remedial action. In terms of the report of the Public Protector, she instructed with remedial action the Chairperson of Parliament's Justice Committee, Dr. Motshega, to start proceedings to amend the Constitution. Would you agree that that is something completely different from somebody who would suggest that maybe we should look into some provision in the Constitution?
Chair, I agree.
Thank you, Chairperson. My last question deals with the two emails. That's one that deals with the quality assurance. And there was at some stage some uncertainty in terms of the date. The date of the first email was the 18th of May, 2017. And the second email was a month later on the 17th of June. Are we talking about the same report when these two emails were relevant? And in one of those two emails, there's a part that says, we also, including the Public Protector, will have to go through this report page by page. Did that actually happen?
Sorry, Chair, I think there are two questions in there. Can the Honourable Member please repeat that for me, Chair?
Let me try. The the first question deals with the first email of the 18th of May. And the second email is a month later on the 17th of June. And in the second email, it said that the other gentleman is not here today, but this is a month later. So obviously, if it deals with the same report, it must be he's not here on that day. It doesn't mean he's not been there for the last month, if he should have done the quality assurance. The question I'm asking is, in one of those two emails, there's a provision that says, or a paragraph that says, and I think it's the one that comes from the public protector, which says the three of us will have to go through this document or this report page by page. It implies that the public protector will also have to go page by page. Do you know if that actually happened?
Chair, I don't recall that happening, Chair.
Thank you, Chairperson. I'm finished.
Thank you. Before I proceed to the next speaker, I just want to recognize, I see Advocate Mpofu, you have your hand up.
Yes, thank you, Chairperson. Thank you, Chair. Yes, no, I just want to point something out that I don't think what Honorable Mulder is doing is correct, Chair, because I don't want to interrupt the questioning, but it's completely valueless to ask the witness whether he agrees with the question that I put. I mean, so what, whether he agrees or doesn't agree with the question that I put to him. But what's more important is for me not to be misrepresented. I really don't take kindly to that. Honorable Mulder said that I said that the witness should not be believed because of his memory, impaired memory. Now, that's a half-truth. It's not even a half-truth, actually. It's a third or less than that. So if you're going to quote me fully, and please do not misrepresent what I said. Because I said that, yes, I did say about the memory, but I also said that the witness is because he's dishonest and evasive and a whole lot of other things. So if you either ask your question, don't say Advocate Mpofu say this, because if you're going to say that, then you must say exactly what I said. I take strong exception to being used as a Trojan horse for questions, using things that I did not say or distorting what I had said or saying only a part of it. The other, anyway, so all questions must not start with Advocate Mpofu said this and so on, and the witness only has to say yes, because that's like legal argument. I'm here if anybody wants to argue with me, not through the witness.
Thank you, Advocate Mpofu. Honorable Melder.
Can I assist, Chairperson? Luckily, no one will tell members of parliament how they should ask questions. Nobody will tell us that. That's our job to do what we need to do. Secondly, all of us are rather intelligent and we could understand exactly the line of questioning that was put to the witness in terms of cross-examination and the impression that was created in terms of that line of questioning. So surely it's my right to ask that of the Honourable the witness to make clear that I understand that he understood exactly what was also said. I did not misrepresent Mr. Mpofu. As a matter of fact, I could go further, but I'm not going to waste the time of the committee and deal with that allegations of dishonesty and everything in that regard. I didn't think it's necessary. The main thrust was that this witness did not remember what happened. I thought it was important to give him the opportunity to clarify that as well. Thank you, Chairperson.
Okay, thank you, Honorable Melder. Maybe before I proceed, the point I'm hearing you on, Advocate Mpofu, is being you would wish that you are quoted in verbatim and not being misrepresented. I think that's a strong point that you are raising. I take note of that.
So, that's fine. Thank you, Chair. That's all really I was, that's all I wanted. Thank you, Chairperson. I don't want to belabor the point here. I'm just saying Honorable Mulder can ask any question he wants, but he mustn't preface it by saying Advocate Mpofu says this. If he wants to do that, then it must be accurate. That's fine. Thank you.
Thank you, Advocate Mpofu. I now recognize Honorable Tseke. Honorable Tseke.
Thank you very much, Chair, and good afternoon, Tate Kekana.
Good afternoon, honorable member.
Thanks very much. Flowing from the question which was raised by Honorable Gondwe on the Friede Dairy Project, the report made mention of 2 politicians who were removed in the original report. Were these the only politicians or public representatives implicated and removed in the initial report?
Yes, if that's my recollection of events.
Thank you very much. In your opinion, Ntate Kekana, did the PP try to protect the public relating to the beneficiaries of Friede Dairy Project?
In my view, Chair, no, because we never spoke about them in the report, Chair.
Okay, thank you. The third one, in your view, did the PP try to protect politicians at the expense of the public in this regard?
Chair, I don't want to express a view on that because I wouldn't be sure. I didn't get any reasons as to why we needed to remove politicians from the report, Chair. So, Chair, I'm afraid to have a view on that, Chair.
Okay, thank you, Ntate Kekana. In your opinion, I know the question has been raised several times, but maybe I'll put it in the other context. In your opinion, what was the reason why the PP was interested in including the submission of the Black Land First in the CIX investigation, despite the fact that they were not involved in the matter?
I still can't offer any view on that, Chair. I don't know even the reasons why the PP had allowed for BLF to provide submissions. So I wouldn't be sure of that, Chair.
Thanks very much, Ntate Kekana. The last question, it was also asked in reference to paragraph 24 of your affidavit. Mr. Kekana, you indicated the idea of nationalization of the Reserve Bank came from the PP, but the wording of the amendment in the report came from the SSA. Is that correct?
That's correct. That's correct, Chair.
Thank you very much.
Thank you, Honorable Grace Tseke. I now recognize Honorable Zungula.
Thank you, Chair. Mr. Kekana, my first question would be, is it uncommon for recommendations to come from those interviewed during the investigations?
Yes, Chair, it would be uncommon, Chair.
So all of the recommendations, they would not take into account the people that were interviewed?
No, Chair, the recommendations, Chair, would come from the PP, Chair, as the public protector, Chair.
After taking into account the interviews, obviously.
Yes, the interviews and all the evidence that she had to consider.
Therefore, it's not common for the recommendations to also come from those interviewed.
No, Chair, it's not common.
No. All right. Okay, let me move on, because just now you just agreed that the recommendations, they do come from the PP who takes into account the interviews.
Yes.
Yeah, okay. So my next question is, in your evidence, you said you complied with the instruction to make amendments to the Constitution, although you did not fully understand what the amendments sought to achieve, and you said they were irrelevant. Is that correct?
That's correct, Chair.
So that instruction, was it unlawful from your perspective because you did not understand and it was irrelevant?
Chair, I would not comment on whether the instruction was lawful or not, but at the time I had to obey the PP instructions.
So you mean you would willfully obey any type of an instruction?
Chair, I'd like to explain that from the context of the circumstances, I was new in the private office and I was new in working with the PP. And Chair, if she gave me an instruction, I wouldn't want to be seen to disobey that instruction because obviously I might be charged subsequent to not following an instruction, Chair.
So you are saying even if the instruction was unlawful, you would carry or implement that instruction?
Chair, I would in fear of recrimination.
Okay, all right. Then let's go to the issue of the Friday report. You state that the PP instructed that politicians must be removed. I know a couple of members asked for a clear indication where exactly were those politicians implicated for them to be removed. You can't remove something that is not there. So are you able to back up your claims with any form of evidence?
Chair, I cannot back that with any form of evidence, but in my oral testimony, Chair, I have indicated that I recall seeing those adverse findings in our previous drafts.
Which draft? There's a provisional report by the then public protector, which is on November 2014. So are you referring to that draft?
Chair, I'm referring to unsigned drafts that were made by our Free State Provincial Office.
Okay, so as you are saying, there's no evidence to back up your claim.
Chair, I don't have that evidence at my disposal.
All right, then these instructions that came from Mr. Ndo, did you ever confirm with the PP if indeed she gave such instructions?
No, I did not confirm with the PP.
So you did not think you should do due diligence by confirming that these instructions that would somewhat damage the investigation. So you just willfully complied with an instruction based on a hearsay from Mr. Ndo.
Chair, I followed the instruction that was given to me by my senior. At the time, Chair, I did not have a good relationship with the PP, so I didn't see fit that I should go to the PP and make sure whether Mr. Ndo was instructing us properly according to the PP's instructions.
But in your testimony now, you are alluding or placing all of the responsibility of those instructions on the PP, not on Mr. Ndo. Do you think that is fair?
I have indicated all along, Chair, that Mr. Ndo was the one who informed us that the instructions come from the PP. And Chair, I've also indicated, Chair, that I never got any direct instructions from the PP in regards to the Gupta links and in regards to removal of politicians from the reports.
All right, okay. Let's go to the Gupta leaks where you similarly you state that Mr. Ndo said there must be no investigation. However, there's an email from the PP which is on the 13th of July 2017. It's sent to the CEO, PP SACO Hamilton Samuel Erika Cilias, where the CEO is instructed to follow up with the Free State to prepare letters to the Premier, MEC, and Minister Zwane on the issue of the Gupta leaks based on the information that came from the Gupta leaks. What do you have to say about that now that there's an email, but in your testimony, you are saying that there was an instruction to ignore or not do anything based on the Gupta leaks?
Chair, I'm not aware of that email, and I don't think in July 2017 I was involved in the matter, Chair. So I'm really not aware of that, Chair. I'm only aware of what I was instructed to do by Mr. Ndo.
Okay. My second last question. The meeting with Advocate Madonsela and the SSA, there were no minutes recorded or no notes recorded. Am I correct?
Chair, we couldn't find any form of record in regards to Billy Masetla minutes, the interview itself, the transcript. We couldn't find anything, Chair.
But you do know that a meeting did take place between Advocate Madonsela and SSA?
Yes, Chair. I was informed by the previous investigator in the private office that record of that minutes or that meeting did exist.
And no minutes or notes or any form of recordings. You could not find any of that.
We could not find any of that, Chair.
Then why would you characterize the non-taking of minutes between SSA and Advocate Mkhwebane as odd?
Chair, it's odd because the normal procedure was to record, Chair, all meetings and minutes, Chair.
However, this one between Advocate Madonsela was not recorded.
I didn't say it was not recorded. I said we could not find any recording of it.
Remember, if something is recorded, definitely one way or the other, there would be some form of record of minutes, notes, or anything that confirms that a recording did take place.
Chair, according to my personal knowledge, I was informed by the previous investigator that such a record did exist. But when we looked for the record, we could not find it, Chair.
Okay, no, let's move on. Then you drafted the CX report, am I correct?
That's correct.
Who was responsible for the quality assurance?
Chair, as I've indicated, it was a process. The investigator would quality assure the report, which meant in the circumstances myself. And then the report would also be quality assured by the quality assurance unit. That would have been Mr. Matlawe. And the PP would do a final quality assurance before she signs the report.
By herself or by instructing either yourself or any department that deals with quality assurance?
Yeah, it will be your last question you ask.
Chair, I don't understand the question.
Let me ask my last question then.
Okay. Go ahead, Mr. Zungula.
Yeah, so my last question is, the disciplinary hearing found that you were dishonest. On your affidavit, you make claims that are not backed up with any form of evidence. And you are saying your memory is impaired to a certain extent. That is why you can't recall most or some of the things that would have transpired long ago. Now, and you know, when Advocate Mpofu was asking about the dishonest issue, you were very, very evasive on answering that particular issue. Why would the committee, or why should the committee take your evidence you know, as the gospel truth or as the truth, whereas firstly, you're found to be dishonest, and the CCMA report states that your dismissal for gross misconduct was fair, meaning you are not a person of integrity. Why should the committee take your testimony as a gospel truth?
Chair, I answered all the questions to the best of my knowledge and truthfully so, Chair. And Chair, the remarks by the chairperson of the disciplinary hearing and the award issued by the CCMA, I disagree with them, and that's why there's a pending matter at the Labour Court in respect to that. So, Chair, I don't consider the issues emanating around the findings in the disciplinary hearing and the CCMA being final, Chair. That's why I'm at the Labour Court. But I would like to emphasize, Chair, that I answered all the questions to the best of my ability and truthfully so, Chair.
Okay, thank you. Thank you, Honorable Zungula. May I just make a request that you share with the secretary of the committee the email of the 13th of July, 2017, that came from the PP to a range of people. We don't have that email. Please share it. Thank you. I now proceed to the next speaker. I recognize Honorable Luzipo. Okay, fine, thank you. Honorable Masaule.
Thank you.
Honorable Masaule.
Thank you very much.
When's it dark and dive, Loa?
Greetings, Mr. Kakana.
Good afternoon, Honorable Member.
Let's go to paragraph 15 of your affidavit, where you talk about the provisional report, which was never quality assured but leaked. And you notice that it contained numerous errors and was missing vital information. Now, you are saying that you informed Advocate Mkhwebane of the errors and missing information verbally in your meetings in an office, and Advocate Mkhwebane indicated to you that these issues that you had raised should be attended to. Would you say she was agreeing with you?
That's correct, Chair.
Okay. Now, there are two sets of emails that were projected here. In the first one, it appears that Advocate Mkhwebane was saying that there should be a third party to look at the report with a different eye. Is that correct?
I remember that the email for May, that's the one that the advocate indicated that there should be a third eye looking on it. Am I correct?
I'm not sure. I thought I would get that information, but that's fine.
Well, I was shown those emails, Chair, today after some time, but I think the first email, Chair, was the one in May, where Advocate Mkhwebane requested that a third eye look at the draft.
Okay, so if you were to link the agreement that these issues should be dealt with from Advocate Mkhwebane and this email, would you say that there was an attempt to adhere to your request?
Sorry, Chair, I'm a bit confused. I don't know what request I made. Is it the request that, or the request that Advocate Mkhwebane that I should correct the errors or attend to the errors and the missing information?
Yes.
Chair, I wouldn't like to link that with the emails for May 2017 and June 2017, because at that time, Chair, when I indicated those things, Chair, I hadn't yet started to work on even the investigation or the report. I just read the provisional report by that time, Chair.
Thank you. The working in a very important office like the Office of the Public Protector, when you go into a meeting and take notes, surely you pay serious attention to details, isn't so?
Well, usually, yes, you would try and do that.
And normally what would go into your notes? Would it be only important issues or just anything that is being said, or anything and everything that is being said, or only important issues?
Chair, in making written reportals, I would try to record everything that's been mentioned, but if maybe the speakers are too fast, then I would just indicate brief discussion, or if they maybe mention something, I would just put it as a mention. But yeah, Chair, I think that would be the process, Chair.
So it's possible that the in your notes, the word Heath signified something that was important said in the meeting?
Chair, as I indicated in my testimony, in my notes, I think the main notes, I did indicate that Heath was a reference point, but to my recollection, Chair, we did not discuss Heath, but referred to the investigation of Heath and also the investigation by Davis, if I'm correct, Chair.
Okay. When you do an investigation, Mr. Kakane, and quality assure it before it goes to the quality assurance unit, would you say you do it in such a way that it would meet international standard?
I'm not so sure about international standards, Chair, but we would try to meet the standard operating procedures in the office or the guidelines that have been provided in the office.
To an extent that if it was not to find its way to the quality assurance unit, you wouldn't expect material issues to appear?
Yes, Chair.
Is that an answer?
I think that the purpose of quality assurance would.
My apologies.
Come again, Mr. Kekana.
Chair, I just lost connection for some time, Chair. I couldn't.
Yeah.
Yes, but Chair, sorry, Chair.
Yeah, you were on quality assurance as part of your response.
Yes, Chair, I was indicating, Chair, that in regards to quality assurance, the main purpose would be adherence to the guidelines or the standard operating procedures in terms of report writing in the office, and obviously to eliminate errors, ascertain the law, especially the law to the facts. So that would be the process in quality assurance, just to make sure that the report is, for lack of a better word, solid.
So if it was not the issue of process, meaning a report is quality assured by you, it goes to the quality assurance unit and it goes to the public protect. If it was to happen that it jumps the quality assurance unit, but you quality assured it, and then it is signed by the public protect, would you say that report is not up to standard?
Yes, Chair, I would say that, because then it wouldn't have gone through all the levels of quality assurance.
Okay. There was a point, and this is my second question. There was a point where you you said you read the dairy farm report, Friede. But at some point, you had no appetite to read it further. Is that correct?
Yes, Chair, I did indicate that I read partially the report and I didn't have the appetite to read it further, Chair.
And for you to get to a point where you conclude that the politicians that allegedly Advocate Mkhwebane had instructed that they are not implicated, you would have to read the report to find that that has happened, that instruction has been carried on?
Well, Chair, I knew because remember I was also involved in the removal of the information before it was even published. So more or less, I knew what was in the report.
Okay. In the investigation of CX, during the investigation, did you have a meeting with the implicated parties and particularly National Treasury and the South African Reserve Bank? If not, why did you not meet them? And if yes, were their submissions included in the final report?
Chair, there was a meeting with the South African Reserve Bank before I took over the matter. And we did also get a response from the South African Reserve Bank in regards to the provisional report. In relation to National Treasury, I'm not so sure whether there was a meeting prior to me handling the matter, but I know that we never had a meeting with them, but we did have a response from them in regards to the provisional report, and both responses were in the final report.
Thank you. Lastly, in your affidavit in page 1, number 1, you say that I am an adult male living in Pretoria, employed in the Office of the Public Protector of South Africa as a senior manager. I was comparing your affidavit with that of other people who came, especially Mr. Lochenberg. He says he was a former employee of SARS. Is there a reason why you still call yourself an employee at this moment? Is there a message that you are trying to convey to the committee? I'm asking this because there was a back and forth around your dismissal.
Are you reading from that protected disclosure, which would have been made in 2019?
That's the affidavit.
Yes. Okay, Mr. Kekan.
Chair, when I deposed the affidavit in December 2019, I was still an employee of the Public Protector South Africa.
Okay, thank you. Thank you, Honorable Masaule. Honorable Siabi. Just before you proceed, Honorable Siabi, I see the hand of Advocate Mbofu.
Thank you, Chair. I'm sure it was a slip of the tongue, but please don't act as if you have prejudged some of the disputed issues. It's not a protected disclosure, or at least that's a disputed issue, whether it's a protected disclosure. So we don't want to get the impression that that issue has been predetermined.
Thank you, Mr. Mpofu. That order is not sustained. There's nothing predetermined in these proceedings. Thank you.
No, Chair, can I please intervene then?
What was the point?
Yes, no, okay, whether it's predetermined or not predetermined, I'm saying that the chair should not then categorize a disputed issue as A or B if it's disputed, because that gives the impression that it's predetermined when it comes from the chair. So rather rather use a neutral term or not enter the debate, because otherwise what are we doing here if our inputs are not going to be considered, or rather if they are considered already and therefore they won't enter the final debate.
Thank you, Advocate Mpofu. Honorable Siabi.
Thank you, Chair. Can I start with the request, Chair? If ever it's lawful. If it's not lawful, you will tell me. Most of the times we are given the judgments of the High Court or the Concord. Can I request that where we're given a majority judgment of the Concord, for example, and there's a minority judgment, we be supplied with that also. If it's a High Court, if it's a High Court, just to be advised whether it was a full bench or not. If that is acceptable, Chair, I'll really request that.
That's in order.
Can I now direct my questions to Mr. Kekana? Good afternoon, Mr. Kekana.
Good afternoon, Honorable Member.
Thank you. When were you employed by the PP?
I started with the PP in October 2011.
When were you dismissed by the PP?
I was dismissed in September 2020.
When were you transferred to and from the private office?
Chair, I was transferred from the private office. Sorry, Chair, can I get clarity on that? Does the Honorable Member mean my time when I moved from the private office to Provincial Investigation Integration, or from the Quality Assurance Unit to the private office? Just need clarity on that, Chair.
Maybe let me split it, Chair. When were you transferred to the private office?
January 2017.
When were you transferred from the private?
Sorry, Chair. Chair, I was transferred from Quality Assurance Unit.
No. You worked in the private office, but at some stage you were removed from the private office.
Yes, Chair, that's correct.
When was that?
I was removed in November 2017, Chair.
Okay, thanks. In your statement, you said you were told by the HR that you are transferred to the private office. Did you ask questions why?
No, Chair. I didn't ask questions why. I was approached, Chair, if I would be interested in transferring to the private office, and I didn't have any issues.
Again, you were told by HR that you are transferred or removed from the private office. Did you ask questions why?
Yes, I did ask questions why.
And somewhere you say those questions were directed to the PP. Is that correct?
Yes, Chair, on paragraph 37 of my affidavit, I do state that when I asked why, I was told that the PP indicated that I talked too much with the attorneys representing the office.
Did you by any chance try to verify that information with the PP directly?
Chair, I did approach the PP in her office, and Chair, I didn't ask for reasons. I just indicated to her, Chair, that I didn't understand why I was leaving, but I accepted the decision.
Okay, thanks very much. In your statement, as you were giving evidence, you say some of the information, the report you submitted to your senior, which seemingly later was changed, you did not have a copy of that. My question is to check whether the office, you didn't have a system of having a copy file or having a system of somebody who receives information from you, signs for it, and you keep a copy.
Cheke, can I just be given clarity on which copy of the report we're referring to now?
Now you said, I think it's you said in one of the reports that you prepared, I think it's the CIX report, Chairperson. There was information, the final report was not the same as what you drafted. Am I correct, or am I misrepresenting you?
Chair, I'm not so sure. Chair, I did indicate that the additions or the change of focus in the final CX report had to do with the amendment of the Constitution and the nationalization. That's what I recall, Chair, or unless if I'm not answering the question correctly.
Okay, maybe I didn't hear you well. My last two questions, Chair. Based on your testimony, would you conclude that the PP is not fit for office?
Chair, I really don't want to express a view on that. I did report instances where I observed what I deemed as improper conduct from the PP, Chair, and I did submit that to the Speaker and the Presidency at the time. Chair, I believe that this committee is tasked with doing that, Chair, and I would not like to venture into that space, Chair.
Okay, maybe let me put it this way. In your opinion, does the behavior of the PP constitute improper and or misconduct?
Chair, in my opinion, and in relation to the PDA affidavit, which I deposed, Chair, I considered the actions by the PP to be improper in my view.
My last question, Chair. You said, if I heard you well, you said you were not ready to testify before the committee. Can you just take us through again?
Chair, I did indicate that I was or am reluctant to testify to the committee chair, and I think I advanced 3 reasons, Chair. And I think the first one was that I felt that since this is a public discourse, that my privacy would be affected, Chair. And secondly, Chair, I did indicate that my recollection of certain events may be impaired due to a number of years that these incidences have happened. And I think thirdly, Chair, I indicated that some of the issues were pending at the Labour Court, and I don't want to prejudice that process.
Thank you, Chair.
Thank you, Honorable Siabe, and thank you, Mr. Kekane. Before I recognize Honorable Nodada, I see your hand, Advocate Mbofu.
Thank you, Chairperson. I just want to place something on the record. I don't want to debate it necessarily, but to place it as a formal complaint from us, Chair. I don't know if you understood the point I was trying to make before, because you did not make a ruling on it. You just ignored me. The point I was making was, Chair, when there is, it's not done, when there is a point that is disputed, such as whether that statement is a protected disclosure or not, which we spent considerable amount of time in, unless if we are here just to waste our time, then the chair cannot be predetermining an issue like that. You will remember.
No, Advocate Mbofu. Advocate Mbofu.
Chair, can I finish? Can I finish at least?
Just listen. No, I thought you had raised your hand in relation to an issue that would have been raised by the last speaker. Because what you are now doing, you are repeating the same point that you made before I handed over to the next speaker.
No, I'm making a complaint, Chair. I'm not. It's a different matter. I'm not responding to the last speaker. I'm lodging a formal complaint. Can I be allowed to do that?
I will allow you to do that once I just conclude my speakers.
No, Chairperson. All right, that's fine. That's fine.
Thank you. I now recognize Honorable Nodad.
Thank you so much, Chair. Before I start, can I just check am I audible, Chair?
You are audible.
All right. Good evening, Chair, and good evening to the committee and everybody that is on the platform. Chair, just as an upfront, I just want to say that majority of my questions are actually directed to the public protector, Advocate Enquiry in the main. The questions that I wanted to ask are largely covered by previous speaker, in particular, Honorable Myla. But there's just, 2 issues that I would like to just quickly go into, Chair. And if I can just ask Mr. Kekana, to answer after each question that I pose. Good evening, Mr. Kekana.
Good evening, Honorable Member.
Mr. Kekana, as per your evidence that you've deposed to this committee that you want us to consider, would you say that your evidence relates to grounds of misconduct and incompetence in relation to the public protector on the following issues that you want us to consider as a committee? 1, in relation to the South African Reserve Bank report, which ultimately has been ruled on by the courts. Is that correct?
Chair, it's correct that I reported improper behavior in regards to the CX report, Chair. or CX investigation, Chair.
Thank you. The second one would relate to the Friede Dairy report, which has also been ruled upon by the courts up to the Constitutional Court level. Is that correct?
That's correct, Chair.
The third one would then be in relation to what you have alleged as not being protected as an employee or being harassed. Is that correct?
Chair, it's correct that I also reported on harassment and intimidation by the Office of the Public Protector, Chair. That's correct.
Would it be correct to deduce that based on the evidence that you've submitted today, that you rely when you indicate that this is what you want us to consider around incompetence, improper behavior, misconduct, that you rely mainly or supported beyond the sequence of events that you've painted to us today, to the court rulings that have been made regarding the CX report, as well as the Friede Dairy report, which in some instances corroborates what you have presented to us today as evidence.
Chair, I would be more comfortable that I relied on the personal knowledge that I had, which is alluded in the affidavit with the annexures, Chair. I never mentioned any court judgments, but I just mentioned that in the court judgments that the reports were set aside, but I did not place much reliance on those judgments, Chair. I only relied on the information that was in my personal disposal.
Thanks, Mr. Kegan. There's been a statement that has been made by Advocate Mbofu, who represents the public protector, and the quoting verbatim that these court judgments are in fact wrong. That was the word that was used. Do you believe that based on you referencing them in your evidence, this committee should consider those judgments on the CX report as well as the Friede Dairy report?
Chair, that's difficult for me to pronounce on. I think the committee should. Well, it's within the committee's purview, but I think the committee should consider what is relevant to them and make an adequate decision around what they consider as relevant evidence, Chair.
Let's pause, Honorable Nodada. Advocate Mbofu, I see your hand.
No, thanks. It's fine, Chair. Really, thanks. Thank you, Chair. I waive my right to speak.
Okay. Thank you, Advocate Mbofu. Honorable Nodada.
Thank you so much, Chair. Mr. Kekana, according to the affidavit that you deposed, paragraph 33, you indicate there that, if you can just go there, but you indicate there that Advocate Mkwebanga indicated to you that during the review proceedings, that you should not or you should omit some information in the Rule 53 record. Did she give you reasons as to why you should do that? Particularly the information in relation to the investigation that she had done in her tenure in relation to the CX investigation. Do you
No,
recall
Chair. Chair, I do recall that. Chair, she advanced no reasons as to why we should omit those draft reports.
Okay, you further go on to say that there's been a telephone conversation where she vehemently disagreed with you sharing that information. What was that conversation? Do you recall that conversation?
What I recall is that I did inform the council at the time and the attorneys that the PP wished to exclude our drafts from the record. And I informed the council and the attorneys who resisted that. And I reported back to the public protector that council and attorneys were resisting that. And she also had her view that no, these things should not be transmitted in the record. But I don't remember her advancing any reasons to me as to why they should be omitted.
All right, Chair, I'm going to request, and maybe I'll get guidance from evidence leader and yourself. If that particular information can be made available to us in transcript as to what maybe the reasons would have been that some information be omitted from the Rule 53 record by the public protector. And maybe after I've done with my questions, then maybe Advocate Bao and yourself can give direction as to what can happen regarding that. Just the last two.
You're actually at the end of your limit. So I'm not sure if you want to proceed at the end of it, because I might have to cut you.
Chair, I think let me leave it there for now. Because
we're still going to interact with the project. Thank you. Thank you.
That's all right.
Thank you, Honorable Nodata. I now recognize Honorable Lagude.
Thank you very much, Honorable Chairperson. Good afternoon, Mr. Kekana.
Good afternoon, Honorable Member.
Thank you very much. Honorable, Mr. Kekana, through you, Chairperson. On your affidavit, paragraph 33. You said that the drafts which were prepared during her predecessor, that is Advocate Mkhwebane, said that they must be included. Then the drafts prepared during her tenure shouldn't be included in that report. Then this matter, you reported it to the attorneys, and Advocate Baum said that the drafts could not be omitted from the Rule 53 record. After that, you had that telephone conversation with Advocate Mkhwebane, who was opposed to this, even though the legal team was in agreement that these drafts must be included. So why would she, in your opinion, why would she not want her own drafts which were drafted in her tenure and allowed the drafts which were drafted during her predecessor, Advocate Madonsela, to be included in the reports, not hers? Then I'll move also to paragraph number 37 of your affidavit. Paragraph 37, when you were removed from the office of the public protector, it was because you were saying too much to the lawyers representing the public protector. Then can you please share with this committee the information that you were sharing with the attorneys, which led to your working relationship to be sour in that office of the public protector? Then we move on to paragraph 40, still on your affidavit, where you mentioned that the public protector advocate Mkhwebane said the evidence that were in the Gupta leaks said shouldn't be included in the investigation. In your own understanding, do you think that the evidence that were there in the Gupta leaks were going to assist in the investigation of the dairy, the Friere dairy? Then also, yesterday you said in one of the meetings, you were not, you were told by Advocate Mkhwebane not to record the proceedings of that meetings, and you were prevented from taking notes when you were in that meeting of the SSA. Was the meeting discussing classified information, or what was it that the meeting was discussing? We would like to hear from yourself, what is it that the meeting was discussing? Paragraph 19, you also said that it was odd for the public protector to meet, to have a one-on-one meeting with one of the attendees in an interview. Is this stipulated in the Public Protectors Act, that the public protector is not allowed to meet with anyone, or is it in the Constitution, or is that your opinion? If you can expand on that one. Then you also mentioned that questions that you prepared were disregarded by the PP in that meeting. So is it compulsory for the PP to focus only on the questions that are prepared for her whenever you have a meeting, or is it allowed for her to come up with her own questions? We want to have a better understanding in this regard. Then paragraph 32 of your affidavit. You said you attended a meeting with Sifanyetso attorneys. During this meeting, you informed the attorneys of the fact that the recommendation in the CX, in the final CX investigation report, had actually been prepared by SSA. What were their reaction to this? Then my second question would be, based on your investigation experience, is it allowed for the office of the PP to seek and expect advice on a matter like she did with the CX?
Your voice is louder than that.
Oh, hey, we had a very long day,
Yeah.
Honorable Chair. I'm saying, is it necessary to get an expert advice
with regard to any investigation that the office is conducting, like you did with Mr. Model, who is referred to as an economist. Is it allowed? Then, according to your knowledge and understanding, Mr. Kekana, who is better placed to deal with the amendment of the Constitution of the Republic of South Africa? If you can also assist us in that regard so that we can all have a better understanding. Nationalization was not part of the scope of the investigation. Would you say extending the mandate of investigation in this instance would constitute improper behavior? Alternatively, is it common practice for the public protector to change the mandate or the scope of any investigation? Thank you very much, Honorable Chair.
Thank you, Honorable Tlakude. Mr. Kekana.
Yes, Chair, I'm still here. I'm just still recording the last bit of it.
Okay, fine.
Chair, I hope I've captured the questions right. I think in regards to paragraph 33, Chair, Chair, I wasn't given any reasons why we shouldn't include the draft reports that we have drafted. No reasons were advanced at all by the PP. She just didn't want them to be included in the record. In regards to paragraph 37, Chair, Chair, the information that I shared with the attorneys, Chair, was in relation to the amendment of the Constitution, Chair. And that's what I recall advising them, and also indicated to them that we received a note from the SSA with the changes, Chair. Chair, in regards to paragraph 40, Chair, we were instructed to follow up on the Gupta leaks. Chair, depending on what we would find, Chair, that was going to determine as to whether that information would assist us or not. But I think if I remember correctly, from media articles then, there was mention of Friede in the Gupta links. So, Chair, it was a lead that we wanted to follow. And if there was any information that was relevant, we were definitely going to use that information, Chair. Chair, in regards to being told not to take notes or make a recorder of the SSA meeting, Chair. Chair, from my knowledge, the information that we were, or that was discussed in that meeting was not classified, Chair. As I indicated before, Chair, the discussions mostly centered about the Reserve Bank pre-democratic era, Chair. And Chair, on paragraph 19, Chair, Chair, according to my knowledge, there was no written rule per se that one could have a one-on-one meeting with an implicated party. It's not stipulated in the Public Protector Act. It's not stipulated in the Constitution. but the practice of the office was not to have these one-on-one meetings with affected parties in regards to an investigation meeting, Chair. Chair, in regards to the prepared questions, Chair, it was not compulsory for the PP to focus only on those questions. She would use the questions to assist her, and she could also come up with her own questions, Chair. Chair, in regards to paragraph 32, Chair, after I told Sifanyetso attorneys about the SSA amendments, Chair, I remember the reaction was that of shock, but I don't remember the specific words that they responded me by, or the response that I got from Sifanyetso, but I remember that there was some shock from the attorneys. Chair, in regards to my investigation experience regarding experts, Chair, we are allowed, Chair, to seek an expert if required, Chair, and that is allowed, Chair. Chair, in regards to the constitutional amendment, Chair, I think Parliament or Cabinet is better placed to deal with any amendment of the Constitution, Chair. Chair, also in regards to nationalization, Chair, Chair, I believe that it was not in our scope to follow that line or that theory, Chair, and it was wrong of us to follow that course of line in regards to nationalization. And yes, I do believe that the scope of the investigation did change because of that, Chair. So I'm not so sure whether I've captured everything, Chair.
Yes.
Thank you very much, Honorable Chairperson. Paragraph 40.
Is that something that he missed responding to?
Yes.
Okay.
Yes. Still on he said on this paragraph of his affidavit, much of the evidence needed for the investigation was contained in the leaked emails of members of the Gupta family, known in the media as the hashtag Gupta leaks. Then my question was, if they were not prevented from taking that evidence from these Gupta leaks, was this going to assist with the investigation?
Okay.
Thank you very much.
Mr. Kagan.
Chair, we did believe that it was going to assist with the investigation.
Thank you. Honorable Maneli.
Thank you, Chair. Greetings, Mr. Kekana.
Good afternoon, Honorable Member.
Good afternoon. Chair, I would want to just start by ascertaining first with regard to the two reports, and this is a matter I would want to also conclude with. Were these reports or investigations, let me refer to the investigations as a starting point, were these investigations done before you were involved in the investigations, Mr. Kekana? Secondly, were these done before the current public protector we are now referring to, meaning they were done by the predecessor in that regard. So I just want that to be again ascertained, that that's the case.
Chair, yes, we both the CX investigation and the Freddie Dairy reports or the Freddie Dairy investigations, the both investigations happened before the public protector advocate Mukwebane was appointed as the public protector. So we inherited both investigations.
So in that score, just to follow that up, isn't it that then the expectation would be there were handover reports that would have been laid as the basis for you to continue with the investigation?
Yes, Chair, I agree. There were handover investigations that we needed to finalize. That's correct, Chair.
So in that score, Chair, I'll start then from the Friday report. Just to check there again, you've made reference to, I think most members would have spoken to this, of being instructed to remove certain information which included politicians. Are these so-called adverse findings you're referring to emanating from the handover reports, or they are emanating from an investigation that you yourself has undertaken?
Chair, they were emanating from draft reports that were before our time, Chair.
So would you say that in essence, the first task that was given by Mr. Ndo was really to alter what was in the report handed over to you by so-called Mr. Celia?
Chair, the first task that we were given was that we should follow up on the Gupta leaks, Chair. And later on, Chair, we were instructed not to follow up on them anymore, Chair. And then later on, Chair, we received an instruction from Mr. Ndo. I think this would be just before we reviewed or removed most of the things in the report. Just before that, we received another instruction from Mr. Ndo that we were to remove any adverse findings in the report, Chair.
Would you then, through your chair, would you then, Mr. Kekana, say that you yourself personally, given your experience as an investigator, you would have agreed with these adverse findings, and it's the reason you are raising with the committee on the instruction to remove them?
Chair, I had no reason to believe that the previous investigators who had made the findings, that they had made inaccurate findings. I myself was just to proceed with the investigation. And if there was or there would be evidence that would indicate that the adverse findings were incorrect, then we would amend that. But from our point of view, Chair, we moved with what we were handed with, or what we received.
Maybe, Chair, just to complete that point, as it relates to the leaks and the instruction not to follow that through, I'm just looking at what this committee is expected to look at. Was this based on the legality of how this information was obtained? Or are you trying to demonstrate that this was a deliberate move to withhold information to weaken the strength of the investigation or the actual report at the end?
Chair, I'm not really sure. As I indicated before, we were not given any reasons as to why we should remove these adverse findings, Chair.
Maybe put differently, Chair, as an investigator who needed to use this, would you yourself say you believe that this information was, from a test of legality and how you obtain it, usable for you to make decisions?
Sorry, Chair, can I get that again?
I'm asking Mr. Kekan, just you yourself, besides the instruction given or these leaks, is it information that you believed should be used? I'm saying from a point of legality on how this information would have been obtained.
Chair, ours, especially on the Gupta leaks, was to follow up on that lead, get the information, assess the information, and if we were to find that the information was credible, we would have used it. And if the information had no value, we wouldn't have used it, Chair.
Just again on Mr. Ndo, as I complete my questions on this one, on the Mr. Ndo question, you took the instructions, you indicated that you didn't question those. Just the role of Mr. Ndo, I just wanted to check whether it's been common practice that you would ask that certain information be removed from the reports and it will go as such, or it is just an experience on this matter?
My experience was that usually we would be given reasons as to why we would remove something from a report. But in this instance, no reasons were advanced. We were just informed by Mr. Ndo that we had to remove the information.
But then, Mr. Kekana, I just wanted to check, is that like common in practice that this would happen? Because I'm also trying to establish why you didn't discharge the duty of a public official to check if something is unlawful, that you are able to say no.
Chair, I couldn't say no, and especially if Mr. Ndo indicated that the instruction came from the PP, Chair. And Chair, I just acted according to what we were instructed to do, Chair. As I indicated, Chair, usually when we remove things from a report or from a Section 7(9) notice, it would be informed by facts or evidence. But in this instance, no reasons or facts were provided to us for such a removal, Chair.
Would you then believe that those omissions or removals would have had a material impact in the investigation or the final report?
Chair, I agree with that statement.
Then, having not raised this even with the PP to validate whether Mr. Ndo's instructions are indeed lawful, any other avenue that you would have used, you've already described your relationship with the PP at the time, but any other avenue you would have used where you think these are like unlawful instructions that may compromise even what you referred to as standard operating procedures in the office?
Chair, I don't think there was any kind of procedure as to where internal staff could report the behavior of the public protector. So, Chair, I didn't report it to anyone at that stage up until I made the protected disclosure affidavit. Chair.
That's on 42, again, the meeting in the boardroom. Here, it is not Mr. Ndo or hearsay that Mr. Ndo says this. Here you are saying it's a direct instruction to remove certain information from the report. I just want to check it again. At this point where it's a direct instruction, the matter of politicians involved would have not arisen.
Chair, in that meeting, I don't remember the issue of politicians arose. I think we focused on other things since we had already received that instruction for politicians.
No, thank you, Chair. I didn't want to get back to the other report on the Reserve Bank. Maybe the starting point.
You're towards your limit.
Yes. The starting point will be on the PLF included in the investigation when it is not supposed to. I just want to check it from the other side. Would you have regarded this as a way of, I'm saying, from what is expected also from a public protector, protecting the public and listening to what the public would raise, that it was merely that exercise and that is why it would have not even made it into your report?
Chair, I can agree to that proposition that maybe the public protector was just or wanted to hear an organization on what they could possibly contribute. So I would agree that that might be the case, Chair.
Yeah, maybe my second last question, Chair, will relate to this SSA meeting. I just wanted to check there. You continuously said no recording and this was not in the report. My question would be that this was an opportunity, as you stated, to hear the other side of the story. What did you rely on then to the finalization of the report in the absence of this part?
Well, there was nothing basically, Chair. As I indicated in my earlier testimony, we did expect a written submission from the SSA, and we really never got it. So what I think was indicated in the report was statements made in the provisional report, Chair, if I'm not mistaken, Chair.
My last point, Chair, like I said, I will come to conclude with this point as I started with it. In both reports, would it be correct to draw a conclusion taking into account that the Reserve Bank investigation looked at something and at the end you ended up having even amendments about the Constitution and all that? Then on the freer side, you also had removals that also changed the report. Will it be correct then to draw the conclusion on both reports, which are inherited, where there's been handover, that necessarily you are saying those reports would have been altered from what could have been originally the intention of the two investigations? Thank you.
In general, I would agree with that assessment.
Okay, thank you. Advocate Mpofu, if I may get your attention. Thank you.
Yes, Chair. I'm here, Chair. Sorry.
Thank you. No, I just wanted to attend to the query that you had registered and indicate that as you would have witnessed that from day one of these hearings, we were very clear about this committee starting with no predetermination on anything. And secondly, I am very much alive to the fact that you would have spent considerable amount of time, especially yesterday, not only canvassing, but also at the end, you did register your own dispute on the issue of the Protected Disclosure Act. So that has not gone unnoticed and it's registered as such as a dispute. And further to make the point that this committee is still going to have deliberations on everything else that would have been placed in front of it. And that there is no member, including its chairperson, that will preempt those deliberations. So if your point was to register that and redirect the chair to that dispute, the chair is well directed to that dispute. I wanted to make that point before I allow you.
No, thank you, Chair. No, I'm happy with that, Chair. I just wanted, remember, this is a public process, Chair, where it's not just all of us in the theoretical room. And so, Chair, it's really incorrect. There's no other way to describe it. To say, Chairperson, that something, I mean, this witness, for example, the reason I let him get away with calling this thing a protected disclosure is because he says he doesn't even know whether the speaker is a member of the cabinet or not. That's fine. We can argue all that at the end, as you say, Chair. But you know that the speaker is not a member of the cabinet. So for you to then sound as if, and that's why I started by saying, Chair, maybe it was a slip of the tongue. I was not suggesting anything more than that. But to sound a neutral person, if there's a whole dispute which takes 10, 15 minutes about whether this is a protected disclosure or not, or whether it's black or it's white, and then the chairperson then just says, oh, this black thing, that means the other side is being neglected. It's just a simple point that I'm making, and I don't want to make a meal of it. I just want to ask all of us actually to be sensitive to those kinds of things, because you might say that there's open minds, but as we go on, we start to get the impression that there are fixed positions, and there are even attempts to undo or to re-examine the witness, to undo questions or to repair questions where he was weak. That's all fine because we're not in a court of law. But let's at least take it easy on the predetermination and at least give a semblance of fairness. It's all from a fairness point of view, Chairperson. I was not.
Understood.
Not accusing you of having done it deliberately.
Understood. Thank you very much. Is there any other point you wanted to make? You said you wanted to make at the end before I wrap up? I'm recognizing you, Advocate Mpofu.
Oh, sorry, Chair. Sorry, I was talking. I didn't realize that I was muted.
You will have to start again then.
Yes, no, I was saying, Chair, it's a very quick point, and thank you, Honorable Chair. This is the right point at which I should make that point. And again, it's for your consumption, but also for the public out there to follow all the steps that we're taking. You would have, Chair, received a detailed letter from us yesterday. You remember that's the letter I had promised you, and I said we were still putting a few editing touches.
Yes, yes.
Yes, it was sent and acknowledged by your office, Chair, yesterday. And it raises quite fundamental issues. And the purpose of the letter, I'm not going to discuss it now. The purpose of the letter, as it says, is for you to table it at your meeting in the next couple of days. The only reason I'm raising the issue now is because one of the issues raised there, I think there are 6 broad issues that are raised there. 2 or 3 of them might have been issues where we were bolstering some of the issues we raised at the beginning. And another 2 or 3 might be completely new issues. You will deal with it in your own meeting. The only relevance or importance of raising it now is because one of the issues that we raised sharply in that letter is the fairness and reasonableness of this procedure of interposing questions after every witness to Advocate Mkhwebane before she gives evidence. And yes. I do understand that it is that ruling is still stands as we speak now. But I just want to indicate once again that that procedure is completely unheard of and completely unfair, because if it goes like that, by the time we have to give evidence, we might have been asked questions about everything else. So there might even be no point in giving any evidence, number one. Number two, we are still preparing. There are still witnesses. We don't want to precognize, as we call it, witnesses about certain information. I'll give you an example. Mr. Pillay, who's still going to testify, his evidence is almost related to that of Mr. van Lochenberg. So if we are going to be dealing with those issues, then Mr. Pillay will be recognized of everything, of everything that we have, of the answers, and be able to tailor his evidence accordingly. And that is inherently unfair. And I'm simply saying that's why I'm saying this is the correct time to raise what I'm raising, Chair, because I suspect that this is where you might want to allow people to do exactly that which we wish to record is inherently unfair. Thank you, Chairperson.
Thank you, Advocate Mpofu. You have registered quite a number of points, and fortunately, you derive them from the letter that will be for the attention of the committee tomorrow, and we will certainly attend to those issues as the committee. Thank you for that. Advocate Bauer, I see your hand up.
I was asked a question earlier, but I'm not sure what the question was precisely. My apologies. One member asked at the end, the evidence leader should address the question relating to the transcript of the Rule 53 record.
It was on Honorable Olomisa.
No.
Not that. Okay, you had forgotten about the question.
I've forgotten the question.
You want to remind her, Honorable, not that?
Yes, Chair.
Just please do.
Yes, Advocate Bauer, I referred to paragraph 33 of Mr. Kekane's evidence or affidavit, if you want to put it that way. And paragraph 33 of that affidavit indicates a telephone conversation that took place between him and Advocate Mkhwebane regarding the Rule 53 record not being produced, particularly from her own investigation for the 6th report. So I was asking whether we could get a recording of that or a transcript of that particular conversation to ascertain what the reasons behind the non-disclosure of that particular report was, particularly in the review proceedings.
Did you get that, Advocate Bauer?
I did, but I think we must ask the witness whether he has a recording of that telephone conversation, because we certainly don't have it in our possession.
When you say the witness, Mr. Kekan. Okay, thank you, Advocate Bauer. A quick one, Mr. Kekana, did you hear that? Do you have that recording?
No, Chair, I don't have that recording, Chair.
Okay, thank you. Honorable Mulder.
Thank you, Chairperson. Through you, if I may just get clarity from Advocate Mpofu to understand what he's saying with regard to the evidence by the public protector. Obviously, the public protector plays a central role in these proceedings. And he argued that in terms of fairness, it would not be fair to allow questions being asked to her throughout the process. Now, we've got our own meeting to discuss the process forward. I want to understand. I think we're dealing with a dual process. On the one hand, written questions or questions can be asked to the public protector. That happened earlier last week, if I remember correctly.
Friday.
And the indication was that it will be done in writing. I understand that's one process. The other process would be where the public protector gives evidence in person, like the other witnesses have done so far, and that's a different process. Do I understand Advocate Mpofu correctly? Are you indicating to the committee that the public protector is going to give evidence in person directly? And because of that, we should not proceed now with questions that demand written replies. I'm just trying to understand what he's saying. Thank you.
Sorry, sir, can I?
Okay. I've not recognized you. Please go ahead.
Thank you, Chair. Thank you. I'm sorry about that, Chair. Yes, no, thank you, Honorable Mulder. That's quite an important question. Yes, indeed, Honorable Mulder. What I'm saying is the system that has been adopted of asking the public protector to give answers in between every witness is inherently unfair for the reasons that I've articulated both just now and also in the letter which will be tabled before you. So I don't want to get into that in great detail. And you will recall that I raised this on day one. And my proposal, which was obviously rejected by the committee or the chair or both, was that the public protector, the questions obviously should be posed, but that those questions be answered either when she gives evidence or I can't remember the actual wording of the amendment we were suggesting, or we said 5 days after she indicates that she will not give evidence. And I said on Monday, that is exactly to avoid the kind of situation we find ourselves in now, where we are going to be having, because you run out of that 5 days or 7 days or whatever the chair might regard to be the reasonable time, at points that are randomly selected just by coincidence. And therefore you might have to give those answers before, for example, critical witnesses on a particular point. And it just distorts the entire hearing. I've never heard of such a procedure in my entire life in any proceedings of whatever shape or form. And the only justification that has been given for it is the fact that the public protector accounts to Parliament, which is true. But this is not that type of accounting mechanism. This committee has a specific mandate to ascertain the veracity of the charges. And therefore we can't use it for the normal accounting functions. And therefore, insofar as it has a specific function, that function must be done in a fair manner of an inquiry, because it is an inquiry. It might happen that next week the public protector is called into the whatever committee she normally accounts to account. That's fine. But this process here we must guard jealously its fairness, because otherwise it will be a mockery if she has to come, let's say, a month later, but 3/4 of the evidence has been given in dribs and drabs after each witness. Quite apart from wasting time in a process like that, it's just inherently unfair. So yes, Honorable Mulder, you've understood my point properly.
Thank you. Thank you, Advocate Mpofu. I don't want us to get into any discussion on that. I think the point raised was to clarify, to understand what was being placed by Advocate Mpofu. I think we'll leave it there. We'll have our own consideration when with our own house matters and reflection on the process in our own meeting. Yes, Advocate Mpofu, you still want to speak?
No, Chair, it's just a quick one on a lighter note. I was going to say, I noticed that Honorable Mulder did not take the opportunity to ask questions in that fashion last week. So I hope everyone can follow his example. Thank you. I won't go to Honorable Mulder because I think you were here today. Members in their own way had a particular way to deal with this. So we're not going to follow Honorable Mulder. They will follow what they determined to do. Thank you.
Please don't push us. Don't push us. Some corner. Thank you, Advocate Mpofu. Mr. Kekana.
Yes, Chair, I'm still here, Chair.
Still there.
Yes, Chair.
Thank you. We have concluded our interaction as a committee with you, full 2 days since yesterday and today. We want to thank you for your participation, high level of discipline, and hopefully this is going to assist the committee in its own work that it has been set up to do. We really appreciate the role you're playing as this committee. So with that, want to thank you, and at this point to excuse you. It's been a full 2 days. Thank you very much.
Thank you, Chair. I'm much obliged.
Anything you want to say?
No, Chair. Thank you. Everybody have a pleasant evening, Chair.
You sure you don't want us to just do another 20 minutes?
Chair, that's not a good joke, Chair.
Thank you very much, Mr. Kekane.
I'm available, Chairperson.
No, I won't go there. You are excused.
Thank you, Chair. Thank you all.
Thank you. The time now is 20 minutes past 6. Honorable members, if there's no other issue from the evidence leader and Advocate Mpofu, I would want to conclude this meeting with a brief remark that I would have held back. You fine? Come again?
When are we resuming the hearings? Just confirm the date.
Please, please do that. Mailam and then Mahlaule, before as you prepare to do that.
Thank you, Chairperson, and I think Honourable Mahlaule was before me, but I thank you. Chairperson, my question is this. So I know that we're going to discuss it tomorrow, what Advocate Mpofu raised. But in the meantime, the situation is that the directive stands. And as such, we do, as members, have a right in terms of that directive to question Advocate Mkhwebane and Advocate Mpofu over the evidence that we've heard over the last 2 days. So are we going to get that opportunity now, or when will we get that opportunity?
Well, I did not, because I think there were only 2 people who indicated that. So don't try your luck. It was only Honorable Heron And I don't know who, it was not you.
Me, Chair, it was me.
No, no, I think it being this time, and I'll check Honorable Heron if he feels strong about continuing with that.
Chair, if I may, I think it would be important for the committee to discuss the issue that Advocate Mpofu raised, because I'm concerned that we're accumulating a whole lot of questions ahead of evidence that may still come.
Thank you, Honorable Heron. Honorable Notata, you were the second one who did make a reference to a possibility to ask the public protector. All others are being provoked.
Chair, I think I made it clear up front that I've got questions, and there's quite a lot, Chair, but it's up to your discretion whether we do those questions now or at a later.
I'm going to appeal to you to hold them, Honorable Nodat. Hopefully that won't be a train smash for you. Are you okay
That's
with
fine.
that?
Yeah, that's fine, Chair.
Thank you. Advocate Bauer.
Chair, I addressed my... Yes.
Okay, Mika. Honorable Slama.
Because you were closing, Chair, and you wanted to make remarks, I only wanted directives on tomorrow's meeting. Is it the same arrangement or virtual? So that you close your meeting.
Yeah, that will be an announcement when I'm done. So you're a bit ahead of me, if it has not been communicated already. Thank you, Advocate Bauer.
Maybe if this could be raised with the committee tomorrow, we set to adjourn. I think Advocate Mpofu asked for 3 days, and then 2 days is the Western Cape High Court hearings. So we set to adjourn on the 27th, or to come back to this on the 27th, and resume. I have essentially 2 questions. Are we tacking on the 5 days that is lost at the end? In other words, the next week, because it would assist us in sorting our diaries. And the second thing is we have a program. The reality of the progress that we've made up to now is an indication that the evidence is not going to be finished on the program as predetermined. And the committee needs to have a conversation about that when they meet tomorrow as well. And yeah, as things stand now, we're back on the 27th.
Yes, and then that will be finalized after tomorrow, because the amendment of the program is in front of the committee tomorrow. So thank you for that. I was elected to your hand, Advocate Mpofu.
Yes, thank you, Chair. Another quick one. I agree with what my learned friend has said, and I'm sure the committee will relook the program as you indicated. I just wanted to flag from the letter that we have raised an issue there about the possibility of the case next week running over into a 3rd day. We have written to the court as well in respect of that, and that issue will probably be resolved around about Thursday as to whether it's going to be 2 days or 3 days. We will find a way to keep in touch with you, Chair, on that. But I think in fairness, want to raise it that there might be, rather if the court hearing spills over, then it might mean that we resume on the 28th. I don't want it to be discussed now. It's in the letter. I'm just flagging it up because I know people's diaries are quite difficult to manage, and we're dealing with too many people. So we should raise these things as early as possible. Thank you, Chair.
Thank you, Advocate Mpofu. To be considered, hopefully, if we can get from our legal services team that clarity tomorrow morning. Temi Ngoma, can you just announce tomorrow's meeting? Is it virtual or hybrid? Thank you, Chair. Good evening, honorable members. As some of the members have already accepted my meeting invitation, Chair, the meeting is virtual and it's starting at 10, ending at 1 o'clock tomorrow. So please, members, don't come to the venue. There'll be no one here. Thank you. Thank you. There you get it, Honorable Mahlaule. With that, colleagues, I think that's where we will pause. And I think I'm even holding back on the points I was going to make. I'll make them first thing in the meeting tomorrow, in our committee meeting. Thank you very much. The meeting is adjourned.